No. May I please?
For judgment, item number 1.
I beg to appear for the petition.
Your Lordship, if I may be allowed to mention a matter. Your Lordship. If I may be allowed to mention.
Come on Monday. May I please?
I beg to appear for the petitioner, my lord.
Item 1 for judgment.
Accordingly, WPA 14533 of 2023 is allowed on contest, thereby setting aside the impugned order of suspension dated June 19, 2023, passed by the respondents against the petitioner, annexed P8 at page 188 of the writ petition. All consequential actions, if any, taken pursuant to the said order stand hereby reversed as well. However, nothing in this order shall prevent the respondents from proceeding with any investigation against the petitioner and take consequential steps independently in accordance with the guidelines. No rest to cause, Sergeant certified copy.
Grateful, Lordship.
To be mentioned, item 2.
This
Yes.
was also mentioned, praying for a release, on the ground that it has been filed in wrong determination, Group 9.
Or not withdrawal.
Not withdrawal, Your Lordship can sees the mention.
What is the release for?
For removal of unauthorized encroachment on the government.
Unauthorized encroachment falls within residuary.
That to that, Mr.
Next matter also yours.
No, my lord, this is Achinto Vishwas.
It is submitted by learned counsel for the petitioner that the matter pertains to determination of a different bench. Full stop, however, comma, it transpires from the prayers that this court has determination. Full stop, accordingly, let the matter be listed before this court under regular heading. Yes. Great.
Item number 3.
I appear for the petitioner, Lordship. This is
Yes.
for withdrawal.
Yes.
With
My lord, I am
to
for
file
the
afresh, my lord.
With liberty, I'm doing that. Granting liberty to file it. Learned counsel for the petitioner seeks leave to withdraw the writ petition with liberty to sue afresh. Full stop. Accordingly, WPA 16760 of 2022 is dismissed as withdrawn with liberty to the petitioner to sue afresh on the self-same cause of action. No rest to cause.
Grateful.
Grateful.
Item number 4.
Item 4, my lord, I beg to appear for the alleged contempt, my lord.
What is the alleged contempt?
Lordship, there was, my lord, a rule, my lord. The Lordship was pleased to issue a rule, my lord, on 19th January 2024, my lord.
Yes.
For non-appearance of the alleged contempt, my lord. My lord, in compliance thereof, my lord, the learned, my lord, that is alleged contempt, my lord, is before your Lordship, my lord, with folded hands, my lord.
Why was the rule issued, Mr. Galib?
My lord, kindly sees, my lord, the order dated 19 January 2024, despite service, none appears for the alleged contempt. Paragraph 2, my lord. 19 January 2024, Lordship.
Why wasn't he present, Mr. Galib? On that.
My lord, service was affected, my lord. So, my lord, it was on 15th September 2023 and 5th October 2023. Twice the service was affected, my lord. My lord, the 5th October 2023 service was affected.
I want to know why he did not appear.
No,
Why he shouldn't be jailed from here right now.
no, Lordship.
There was a specific direction for him to appear and personally explain. By the order dated, if there was a specific direction, Mr. Galib.
19 January is the order, my lord. Today is the returnable date, Lordship.
Acha. Before
Today
that,
the-
there was no direction to.
No. Today is the
Acha,
returnable date.
very.
My lord,
Why didn't he comply with the order?
my lord, he is with folded hands. My lord,
Let him,
before your
let
lordship.
folded hand won't do,
Miller-
Mr. Galip. Why didn't he
Lordship,
comply with the order?
May I, lordship, respectfully hand over a copy of the affidavit.
Tell me verbally also.
My lord, the order in contempt, my lord, may I respectfully invite your lordship the order in contempt, lordship.
Yes.
কপি আমাকে দেবে না নাকি?
That is, my lord. at
Give a
pa-
copy to them also. Yes.
Certainly, lord.
I have not been, sir.
Yes.
My lord, kindly sees, my lord, at page, my lord, 31A of the, my lord, contempt application. The order in contempt, lordship.
Yes. What is the ordering portion? Let us come to that.
My lord, ordering portion, my lord, kindly, my lord, may I respectfully invite your
Page
lordship to, my lord,
34. Yes.
page 34. The respondent number 4, the joint secretary to the government of West Bengal Home and Hill Affair, so and so shall re-adjudicate the issue as to whether the petitioner's name should be recommended for the purpose of getting the benefits of the aforementioned pension scheme upon considering the question of eligibility of the petitioner. In the light of the observations made by the division bench of the court with the order dated 23rd March 2023, passed in MAT number 1901 of 2022, including the observations made by the said division bench in paragraph 14 of the said judgment, a copy of which is also annexed to the present writ petition. Such exercise shall be concluded as expeditiously as possible, positively within 6 weeks from date, upon giving an opportunity to the petitioner to furnish all necessary documents.
Mr. Galip, why was it
Miller-
not done?
Lordship, this was, my lord, we have done, Lordship, kindly, my lord. My lord, this communication of this, my lord, order was made on, my lord, kindly see page 36. On, my lord, 36 of the contempt, communication was made 6 July, my lord, 2023. Lordship, at page 36. Kindly see the enclosures given, my lord, since your lordship was supposed to direct to furnish documents. So at page 37, kindly seize, my lord. I shall not trouble your lordship. Straight away, my lord, lordship may kindly seize, my lord, the serial number 7, the enclosure, a photocopy of the application for pension and the PKC, personal knowledge certificate. So, lordship, the order and the content in this particular lordship was pleased to, my lord, note that his eligibility is to be judged in the light of, my lord, judgment passed in the division bench, my lord, of this honorable court. My lord, may I just, my lord, hand over a copy of the, my lord, division bench judgment.
No, let us see first what you have done.
Lordship,
Page 10 of your compliance.
my lord, for my affidavit, my lord, so thereafter, after getting the communication, my lord, kindly seize, my lord, page 7 of my, lord, affidavit. We make a communication, my lord, on 9th August 2023 to the petitioner himself, asking, my lord, kindly seize the content, my lord.
So it has been forwarded.
The original PKC, kindly seize, my
Mr.
lord.
Galip, I've seen the end of it. I mean, literally the end of it. You have communicated, you have forwarded.
That kindly give us the original.
No, after that you have forwarded.
No,
Come to
kindly
page
seize, my
11.
lord, page 7 first, my lord. We asked, my lord, the petitioner.
That stage is over. I've crossed that stage. Please come to page 10.
Yes,
It is so slow, Mr. Galip.
in,
I've crossed that stage. Please come to page 10.
yes. So we have asked, my lord, because since the
Yes, whatever you have done, ultimately what has been done, let us see that page 11. You have
Lordship,
forwarded.
we have forwarded
Say
to,
that. That should be the only thing which you say.
yes.
Why did you do it on 1st of September? That is the question. Because the communication was made on 6th of July. It was to be done within 6 weeks.
My lord, it was given with the communication was given to the department. Nonetheless, lordship, my lord, this thereafter he retired. The very contempt, my lord, retired on 31st August 2023. So, my lord, kindly seize the communication that was made by the special commissioner so as to comply with the order.
He is a new incumbent.
No, he retired on 31st August 2023, re-employed as OSD with ex officio joint secretary, the alleged contempt on 9th November 2023. So now he is. But, my lord, there was a break.
Yes, what do you say, Mr. Manu? He has forwarded.
My lord, I am entirely depending on my lord. My lord, in due time, I have, my lord, sharp. My lord, they asked me to original. My lord, I again,
No, Mr. Manu, there is no contempt.
my lord,
He had a break in his job in the
yes,
meantime.
my lord,
Not deliberate.
my lord, it is up to my lord.
An affidavit of compliance is filed by learned counsel for the alleged contemner. First of the alleged contemner is personally present in court and is apologetic, as it appears from his demeanor, for the delay in complying with the order of this court. Full stop. That apart, it is submitted by learned counsel for the alleged contemner that the alleged contemner had a short break in his service, since he had been superannuated from the previous post and was reappointed. Full stop, next para. However, comma, it transpires from the annexures to the affidavit of compliance, comma, particularly annexure C at pages 10 and 11, that the petitioner's case has been considered and all the original documents, etc., were forwarded to the Union
And
Government
Lordship,
of
no,
India.
we have asked for originals from the Home and Hill, from the central government. Since he is unwilling to, Millard, he is unwilling to give the original because he's telling that my originals are lying with the central government. How can I
Yes.
give you?
How can I keep?
So we have forwarded, since he has told us that originals are not lying with me, but with the government of India. So we have written this by this letter, kindly this is by page 10,
No, all the original documents.
are lying with the government of India. So we have
What
written,
can he do? How can he produce those?
no, we have written to government of India, page 10, Lordship, kindly see, that is one. That kindly give us.
কি বললাম?
We have given the copies, all the document, copies of all the documents.
No, he has given
27
photocopies, but we.
Please.
Yes,
Yes.
I have given photocopies.
Please, Mr. Manna. না, এটা কেটে দিন। All the original documents which are lying with the government of India have been asked for by the alleged contemner from the government of India in order to process the petitioner's application. Full stop, next para. Hence, comma, there is no immediate presumption of deliberate and willful violation of this court's order. Full stop. Next para. It transpires from the parent order of this court that the alleged contemner was directed to re-adjudicate the issue as to whether the petitioner's name should be recommended for the purpose of getting the benefits upon considering the question of eligibility in the light of the observations made by the division bench. Full stop. Next para, it transpires that as per the rules, comma, the originals of the documents in question, which are now lying with the central government and not the petitioner, comma, are necessary for such recommendation being forwarded. Full stop. Next para. Thus, comma, it cannot be said that there is any immediate violation of the order of this court. Full stop. Next para. However, comma, it is yet to be seen that any effective action has been taken by the alleged contemner in the light of the direction of this court in considering the petitioner's case and recommending the same under the pension scheme. Full stop. Hence, comma, the matter is adjourned till March 8, 2024, when it will be listed under the same heading. Full stop. Next para. For the present, comma, the personal appearance of the alleged contemner is dispensed with, comma, subject, however, to further orders being passed. Full stop. Next para. The alleged contemner, comma, through counsel shall intimate this court as to the outcome of the exercise till now undertaken by the alleged contemner on the next returnable date. So, Mr. Galib, tell me this, ask your client and tell me this. Are the without the originals, don't the rules permit you to do it?
Lordship, rule, I have seen the scheme, Lordship.
It
It
is
has
not
to be
permissible.
verified and scrutinized.
But can I point it to
And
one
since
thing?
there are two PKCs,
But
Yes.
Can I point it to one thing?
Yes, yes.
As per the scheme, 2 copies are to be submitted. One to the central government, another to the state government. Everything is with the state government. What my learned pen is
Yes,
saying.
Mr. Galib, what is your answer to that?
PKC,
as per the scheme,
PKC is
Your-
personal knowledge certificate issued by a freedom fighter, that he was a freedom
He
fighter.
says 2 copies are given. One is with you, one is with the
To
central.
me, the photocopies, an original from his own letter, it shows that we have
Mr.
given.
Manna, on the next date, you will be entitled to file a supplementary affidavit if you like. Satisfy me that 2 copies of the original were
I am satisfied from the scheme itself.
2 originals were to be filed.
2 copies are to be given.
One is a copy.
No,
They are
no
saying that.
original mentioned there.
Then
In the scheme, that is not mentioned, but 1 copy.
there
is
can
to
be only
forwarded
one
to the central government.
personal knowledge certificate. There can be only one
An
original,
original.
which has been forwarded to the central government. You have given.
And
to
he
central
himself is saying that in the letter,
Yes.
that we have
Yes,
given
government. He has
originals.
a point there, but
have
we'll
given-
not dispose of the contempt right now. We'll keep it pending. His personal appearance is dispensed with for the present. Yes, Mr. Garib, thank you.
Original documents with the central government, he is telling from his own.
Tell me the outcome of what happened to that central government. If
Lordship,
necessary, the central government authority shall be imputed by you. We'll consider
Lordship.
regarding that also.
Lordship.
Next.
Item number 5.
There is a
This
grave-
item 3. You are appearing in item 3.
No, no, Lordship. Item number 43. There is a grave urgency, Your Lordship. The
Are
victim
you out
girl
of your
the-
mind? Are you out of your mind?
I apologize.
I'm
Your
taking up a matter. I've taken up some matters. You have the guts to come before the court and mention a matter now.
Your
Never do this. At least in my court. Never do this. You are an advocate of the, you are an officer of the court. Don't forget that ever. That is your first duty. You are an officer of the court. You're not a layman coming here. There's a reason why only advocates are permitted to appear. You have to honor that, sir. Coming up and mentioning a matter, whatever may be the grave urgency. Never do this before any court, at least not in my court. I don't want to see your face again doing this. You are welcome to move matters. I'll encourage you, but not this. See who is appearing for the petition. Who is appearing for the petitioner? Move the matter.
In the writ petition on 30th January 2020,
Use the microphone, ma'am. Why do I have to tell you every day?
Lordship, on 30th January 2020, your Lordship passed the order for consideration of the representation of the petitioner within 6 weeks. The decision to be made to the parties after hearing.
What happened?
But Lordship, the representation, in the representation, there was no wrong mentioning, but in the writ petition, Lordship, the averment, the scheduled plot of land was wrongly mentioned as Mauja.
That is the order which I direct. Show me my direction. Which page?
Lordship, not in the order, no wrong, Lordship. In my writ petition, Lordship. The representation.
This is not a contempt application.
This is contempt
What
application.
is the
Lordship.
contempt? What is the order which is
Lordship,
under
I am
contempt?
submitting. Lordship.
No, don't come. Show me that order.
Lordship, for consideration of the representation and to make
That order, I want to look into that order. Please show me that order. Which page?
But page 8 of the petition.
Thank you.
page 8, annexure A. Page 9, operating portion, Lordship.
Order dated 13 January.
Yes, Lordship, 20. Accordingly, WP 24051, operating portion, Lordship. Last stanza.
Yes. They did not consider.
Lordship, in the representation at page 15, the land schedule was rightly mentioned, Lordship, but in the writ petition, Lordship, at para 2, Lordship, the Mauja was wrongly recorded as Rudranagar instead of Monsadev, and jail number was recorded as 26 instead of 24, Lordship. That to be corrected, Lordship, I have to file the supplementary affidavit, Lordship.
Supplementary affidavit in contempt.
Lordship,
Did they
after that,
consider the
Lordship,
representation or not, Miss Patel?
Lordship, they have considered the representation on
Why have
that.
you filed a contempt
On that
application?
regard, Lordship, they have the petitioner submitted to file the amended writ petition as the cost title was
I don't
recorded
understand what you're saying.
as wrong
In a
recording.
contempt application, the only thing which has to be seen by the court is whether the order as it was on that date, whether that has been complied with or not, deliberately violated or not. Have they complied with by considering the representation?
They have sent a notice for hearing on that regard for wrongly recording in the writ petition, Lordship. They have disposed of the proceedings, Lordship, without taking any decision,
Rightly
Lordship,
so.
and not
There
forwarding
is
the
no
decision, Lordship.
contempt lies, Miss Patel.
Lordship, kindly give me.
Please don't file this frivolous contempt application. I'm telling you, contempt application is an extreme measure.
Yes,
This
Lordship.
is not the child's play. I mean, it's not like a child's play. You file a contempt application, pressurizing the other side. Contempts are filed in extreme cases when they deliberately flout the order of the court. We take measures against them. They can be sent to jail also. So for this frivolous filing, why are you not in contempt? Your client.
Lordship,
I mean, there are instances where contempt rule has been issued against the petitioner in the contempt application because of frivolous filing of application. You cannot use this as a pressure tactics. There was a mistake in your writ petition. They are not responsible for that.
Lordship, I am tendering apology, Lordship, but I am submitting one thing, Lordship. Your Lordship directed to consider the
Action order nahi.
representation. In the representation, there is no such wrong, Lordship.
Learned counsel for the petitioner
Representation was
submits
made
that
rightly.
the representation in question was duly considered by the respondent authorities in terms of the parent order dated January 13, 2020. However, although in the representation there was no error, there was some error in the writ petition regarding the description of the property. It is submitted that such error has affected the final order taken on the representation. Full stop, next para, be that as it may, comma, if the petitioner is aggrieved with the exercise of consideration with the representation and the outcome of the same on merits, comma, it is open to the petitioner to prefer a fresh challenge against the same. Full stop, next para. However, comma, I do not see any reason why the contempt application has been filed, comma, as the alleged contemner has decided the representation upon giving a hearing to the petitioner, specifically in terms of the order of this court. Full stop, next para. In fact, comma, such frivolous contempt applications, comma, adopted as a matter of course, comma, ought to be deprecated. Full stop. Accordingly, CPN 761 of 2021 is dismissed with costs of rupees 1,000 to be paid by the petitioner to the alleged contemner as a token deterrent to the petitioner not to file such frivolous applications in future. Such costs of rupees 1,000 shall be paid to the alleged contemner within a week from date. No rest cost. No rest cost there.
After filing of contempt application, 4 years they have taken the decision and
Very
if the notice for
Great.
hearing of the notice, Lordship.
Item number 7.
I am appearing on behalf of the alleged contempt.
তাও ফাইলটাও তো দিতে হবে।
I am for the petitioner, my lord.
Yes.
On the last occasion, your lordship directed the respondents to file a affidavit of compliance. It has
What
been
is that?
No, my lord. I have filed everybody in compliance, my lord. They have filed exception, my lord.
Yes, he's right.
lordship. The compliance,
Period of compliance says that you have complied.
My lord.
the compliance has been
You
done,
had to file a rejoinder, sir.
It's done, my lord.
the compliance has been filed, my lord.
You had to file a rejoinder today. Where is the rejoinder?
Lordship, I have been instructed to apprise your lordship that the compliance has been done and the
Compliance has been done.
lordship.
So I'll drop the contempt then.
Lordship, it can be dropped with the leave to
Leave
file.
to file afresh.
No, it has
With leave to do what?
with the leave that I may challenge the recent order, my lord.
Definitely. Learned counsel for the petitioner, comma, in his usual fairness, comma, submits that since upon a perusal of the affidavit of compliance and upon taking instructions, comma, he is of the opinion that the parent order of this court has been complied with, comma, there is no need to proceed further with the contempt application. Full stop. However, comma, since the petitioner is aggrieved, petitioner may be aggrieved with the outcome of the consideration by the alleged contemner, comma, leave be granted to the petitioner to challenge the same if necessary. Full stop, next para. Such leave is not required in law, comma, since the scope of a contempt application is only to consider whether the order passed by this court has been violated willfully. Full stop. In the event the petitioner wants to challenge the outcome of the consideration by the alleged contemner, comma, the petitioner is definitely at liberty always to do so. Full stop. Next para. However, comma, since no contempt subsists, comma, CPA 986 of 2022 is disposed of in the light of the above observations.
I'm grateful.
Next.
Item number 8.
Malad order already complied, but only Malad my prayer, Malad kindly see Malad the photograph.
Yes.
But I am for the alleged contemners.
Malad the where Malad kindly leave may be granted Malad to the petitioner to remove the dead wire. Malad this meter already removed.
Very intricate question of laws.
And Malad
Who will remove? You will remove.
I
Remove. Go and remove.
but
Malad,
Malad, as a meter
I'm not interested in your words.
no only Malad
Pritam, ফেরত দাও।
Malad kindly liberty Malad otherwise Malad in
You have
this
to remove words in a contempt application. Learned counsel for
and
the
a two dead meterment is lying. But though this is
whatever is dead,
already
remove that.
three
Whatever is
meters-
alive, keep that alive. Learned counsel for the petitioners submits in his usual fairness that the order of this court has been complied with. Full stop. However, comma, the petitioners submit that there are certain dead wires lying adjacent to the petitioner's property which are required to be removed. Full stop. The removal of the dead wires is beyond the scope of the contempt application, and the petitioners are in any event at liberty to take steps in accordance with law if they so choose. Full stop. insofar as the contempt application is concerned, comma, there is no further requirement, comma, in view of compliance, comma, to continue with the same. Full stop. Accordingly, CPN 938 of 2023 is disposed of in the light of the above observations.
Okay.
Thank you.
Grateful to man.
Thank you. Grateful to you also for complying. Next.
Item number 9.
I appear
Yes,
for the
you are
alleged
the
contemner.
alleged contemner.
I was not here in this matter, but my lord, I have been instructed to my lord, submit before your lordship that an appeal has been taken out. It has been mentioned, and Honorable Chief Justice has been pleased to place it on Thursday, next Thursday.
Next time. I'll keep it after that.
Let me file my supplementary affidavit
Why supplementary?
because on the last occasion we
The-
took the leave to file supplementary affidavit.
Acha, fine.
And
Have you given a copy to them?
Already served. Affidavit services.
Mr. Chakravarti, I'll give you leave to file a rejoinder if necessary. I mean, to this.
Probably they have preferred an appeal.
Yes, I have submitted.
You have disclosed that only in the supplementary.
No. We just came to know in today morning itself.
Acha, very. Learned.
Not only, may I make one?
Yes,
prayer?
yes, Mr.
Your lordship is well aware of the rules framed by your honorable court under the 71 Act. Under Rule 19, rule may be issued or any other order may be passed. And then comes the question of filing of affidavit.
No, Mr. Chakravarti, what we do, we have evolved this process. I'm telling you why. This is pre-issuance of rule. Now, court is not
Your
debarred
lordship
from
wants to give a chance to comply with
to understand whether there has been actually a willful default.
violation.
Only for that reason.
Very well.
Mr. Chakravarti, this is pre-rule stage.
Yes.
So you want to give a chance to the contemner to explain first. If then we are not satisfied prima facie, then rule follows. After rule, you will show cause
And
and
under Rule
whatever.
19, your lordship
Rule
can
19
also
has
pass
not
that-
come yet.
No, your lordship can also pass any order pre-rule stage.
Yes.
Any other order, that is the
Exactly.
language.
Exactly. Mr. Chakravarti, and for the ends of justice, I mean, our intention is not to send anybody to jail, obviously. I mean,
No,
that's the last
contempt-
resort.
This
Or
calculus-
fine.
The celebrated judgment of P.B. Chakraborty, the Honorable
Yes.
Chief Justice,
Yes.
your lordship, Dulal Chandra
Yes,
Ghosh
Mr.
case, subsequent judgments.
Absolutely.
That contempt is also for execution and consequential. review.
Yes.
This view has been accepted by the Supreme Court now.
It should be also. Mr. Chakraborty, the moment a contemner is sent to jail and he cries, we are also crying with him. But we have to establish the rule of law. You know better. Anyway,
Would you be lordship's pleasure to place it after 4 weeks?
I'll do that. Yes,
You-
I'll do that. It is no supplementary affidavit filed today by the petitioner be kept on record. Full stop. It is submitted by learned ASG that an appeal has been preferred against the parent order of which contempt has been alleged. Full stop. Hence, comma, for the sake of judicial propriety and on the prayer of learned ASG, comma, let the matter stand adjourned till March 22, 2024, when it will be listed under the same heading. Thank you. Next.
Item number 11.
Yes. Yes, Ms. Patra. Better case or worse?
On 19th January, your lordship adjourned the matter for directing the appellant to obtain an order from the appellate court.
Oh, contempt is pending. Appeal is pending.
Appeal is
Appeal is
pending, my lord.
pending.
The appellate court, my lord, had requested, my lord, this
Ye-
honorable court, my lord, to defer the hearing, my lord, till such time, my lord.
On that
order
ground,
was placed before your
adjourn the
lordship.
Ah.
But, my lord, I would submit, my lord, that even otherwise, my lord, in my very respectful submission, my lord, there is no contempt as of now. My lord, lordship kindly sees your lordship's order, my lord. I'll just take your lordship. My lord. Kindly sees your lordship's order, my lord. Contempt whereof has been alleged. My lord, kindly take, my lord, page 2 of the order.
Is this the order dated August 9th,
My lord,
2023, 9th August?
yes, my lord, 9th August.
Page 2, yes.
Page 2, my lord.
Yes.
My lord, your lordship has quoted, my lord, from the order passed by the Honorable Supreme Court.
Hmm.
My lord, the Supreme Court, while deciding the said appeal of CSC Limited, bearing civil appeal number 3977 of 1998 by an order dated February 20, 2001, disposed of the appeal on terms as under. My lord, that the appellant herein shall supply high tension energy to the respondents by itself or through its contractor or agent. Now, my lord, this step is being followed by the CSC. My lord, the contractor or agent in this case, my lord, is the developer. That is, my lord, Cityscape, who is also a party, my lord, to the contempt proceeding here before your lordship. My lord, the issue is, my lord, that the premises is receiving, my lord, high tension bulk supply, which stands in the name of, my lord, Cityscape. Now, my lord, we are supplying my lord, supplies or electricity supply, my lord, to all the inmates of the building through, my lord, this Cityscape developers at low tension rates. My lord, that is what, my lord, the purport of the Honorable Supreme Court's order was. Now, my lord, your lordship, my lord, well, your lordship disposed of the writ petition, kindly take, my lord, page 7 of your lordship order.
Mr. Rai, I mean, it cannot go hand in hand. Either I decide the contempt application,
yes,
or I wait for the appeal. I mean, what is the position of the appeal?
My lord, appeal is pending, my lord. Actually, my lord,
Please say.
the appellate court, my lord, is court 12. My lord, there has
Court
been,
12,
my lord, it's not sitting this week also. It
Court
has
12,
not,
who are the judges?
my lord Justice Kesharwani and my lord Justice Bharat.
Then I have to hear her first because she's the applicant.
Yes,
Let
yes,
me hear her, then I'll come to
yes.
Yes, Ms. Patra, move the contempt. What is the contempt?
Lordship, passed the order.
Take your seats, Mr. Bose, Mr. Rai, and Mr. Mukherjee. Yes. You can sit on one another's lap also. I mean, you choose whose lap who will be sitting on.
I'll prefer
Mr. Mukherjee is better be the base. Yes. Yes, Ms. Patra. What is the contempt?
Lordship, the petitioner is the electricity authority
Use
supplying.
the microphone. Although you don't have a good case, maybe, but use the microphone. Yes.
Then Lordship, make it not today only, for my best luck next day, Lordship.
On the prayer of learned counsel for the petitioner, let the matter stand adjourned till 1st March. Need not engage a senior for this, Ms. Patra. You will have to move it, but
Yes,
you get
Lordship,
prepared in the matter and move.
Today I am also suffering for my sickness, therefore I am also
Suffering from
my sickness.
sickness.
Lordship,
Okay, very please come back on first.
fluctuate with the Lordship, I am suffering.
No, not up to the very well. Come back on first. First.
Lord,
Next
Lord,
slide.
can it be, Lord, 2 weeks, Lord? Then in that case, we can try if our Lord,
Convince Ms. Patra, she's going out. I'll make it 2 weeks. Very well. Tell first March na kore March 8.
Maybe, Lordship, as your Lordship
8 March.
chose.
Grateful to you.
Thank you.
8 March.
Item number 12.
Yes. This one. What is the contempt? Yes.
Of your lordship?
My lord, this matter as per lordship direction, my lord, with prior notice to the party, my lord. Our client, my lord, had been to the premises of the petitioner, my lord, for giving effecting connection, my lord. But at the time of when, my lord, nobody was present, in spite of service of notice, my lord, nobody was present on behalf of petitioner, my lord. Only one lady was present, and he said that this is not a common passage. So, and it was blocked by somebody else. That common passage, which was admitted in the court, that this is also common passage and our land. Even then, my lord, we find that there is a blocked by some kacha bera and khor, etc. And there is no scope to enter into the premises. Accordingly, my lord,
You are given liberty to approach the officer in charge. He can remove any hindrance.
Yes, my lord.
That direction was there in the period.
that is not possible for three
For the
persons, my
purpose
lord.
of my lord removing any obstruction, my lord.
3 persons, my lord, when they are kindly see the also, my lord.
What 3
Kindly see
persons?
the,
No, you cannot reopen the case. We cannot reopen the case. I'm sorry. Or by the order under contempt, specifically it was directed for you to give electricity connection. And if there was any hindrance or any padlock was put up, police will remove it. You have to approach the police authorities.
last occasion we approached the police officer, but in this occasion, my lord, they have not approached the
Then that's
police.
contempt. Your officer should
At
be in
that time,
jail.
They were present. Police was also
Whoever
present.
is present, police. Why was electricity connection not given?
My lord, we are very much willing, my lord, to give
Your
connection.
willingness won't
Each
do.
and
You have to
every
give the
occasion,
connection.
my lord, they are, my lord, restrained us. Each and every occasion.
Who has restrained you?
My lord, the private
There are
exponent number
4
5 and
persons,
6.
4 persons, my lord.
Either you speak or let me speak. Please take your seat, sir.
Oh, there are
Please
4.
take your seat.
Now the common
Please let
passage has
me
been
finish
blocked
first.
by one
There was,
Prihori
let me
Bera.
finish first. There was a direction for giving electricity
lord.
supply. If there is any hindrance, something put up in your way, you are at liberty to approach the police authorities. What happened? Why didn't you approach the police authorities?
My lord, in that case, my lord, kindly allow me a 1 day time, my lord. We shall approach the police officer next Friday.
No, but then I'll issue a rule of contempt. Who is the officer in charge?
Kindly, my lord, because since they have
No,
not understand. They
No, Ms.
since
Bhattacharya, no.
they have
No.
approached earlier occasion.
I don't find any.
They could
No, there is no explanation. What the name?
kindly, my lord,
Let him be personally present, he'll explain.
my lord, kindly allow me, my lord, one day time. If not, my lord, in that case, my
What
lord,
will you
kindly
do in one day, Ms. Bhattacharya?
only one.
You are not at fault. What will your client do in?
Wednesday, weekdays, my lord, I am also ready. Kindly. My lord, kindly.
Learned counsel for the alleged contemner submits that due to certain hindrances, electricity connection could not be given to the petitioner. However, this court is not satisfied prima facie with such explanation, since in the order dated December 12, 2022, this court had specifically directed the WBSEDCL to give electricity connection to the petitioner, and if they faced any hindrance in doing so, they were at liberty to approach the respondent number 7 in the writ petition, that is the officer in charge of the Kolaghat police station. As of today, nothing has been produced to show that such steps were taken by the WBSEDCL. At this juncture, learned counsel for the WBSEDCL seeks a week's time to take appropriate instruction on the issue, as a last chance to the alleged contemner to properly explain the conduct of the alleged contemner, the matter is adjourned till March 1, 2024, However, it is made clear that if on the said date no satisfactory explanation is given to the court, a rule of contempt may be issued.
My lord, we shall give connection, my lord, from any place, because there are all places are, my lord, blocked. So, you will, my lord, should I file the report?
No, not like that. Keep it with you. At contempt stage, no report will do. You will have to file either an affidavit of compliance or show cause to the rule issued. Yes.
Item number 13.
May I please, your lordship?
Yes, please. What is the matter?
My lord, your lordship was pleased to pass an order, page 19, on July 13, 2020, for my lord disbursement of the my lord mid-day meal cooks honoraria. My lord, the order was communicated, and kindly see next page. The BDO requested the
What had you done? What work had you done?
mid-day meal cooks. We are.
Oh, you are the midday meal cooks.
Yes.
Right.
OC has directed
Yes.
that law and order should be maintained and order should be complied with. Sorry, BDO has requested the OC. Now, my lord, thereafter we have got
This is appearing for the first time.
first time.
They have not disbursed the money.
No. And my lord, in the meantime,
Yes.
the then block development officer has been changed and new one come. Your lordship kindly give me liberty to add party
Very good.
and serve notice.
Learned counsel for the petitioner submits that the then block development officer, in respect of whom the order under contempt was passed, has since been transferred. Leave is granted to the petitioner accordingly to implead the new incumbent as a party to the present contempt application. Necessary consequential corrections to that effect shall be carried out by the learned advocate for the petitioner during the course of the day. A corrected copy of in view of a prima facie case of contempt having been made out, indicating that the matter shall next be listed on March 8, 2024, when the petitioner shall file an affidavit of service to that effect.
Yes. And here and now I am adding, my lord.
Yes. I've given you that.
Item number 14.
I appear for the petitioner.
Yes, Mr. Mujumdar.
Page 56, paragraph 37 was the positive direction given to the income tax authorities to disburse the arrear of rent at the revised rate fixed by the CPWD. With liberty granted to the income tax authorities to file a civil suit for recovery of the maintenance charges and not the municipal taxes.
Yes. Not given.
Not positively within 31st of May, not on 7th of July 2023, we were served with a copy of stay petition and a memorandum of appeal, apparently defective and beyond time.
Yes, what do you say?
No, he's for the petitioner.
No, this is for the first time appearing for the. Oh, a prima facie case of contempt has been made out by the petitioner. Accordingly, copies of the contempt application shall be served on the alleged contemners, indicating that the matter shall be listed on March 8, 2024 next, when the petitioner shall file an affidavit of service to that effect.
Good.
Item number 15.
Lord, I appear for the petition.
But I appear for the
Pursuant to your
the
lordship direction, my lord, I have
number
already served
two,
upon
the
all
officer
the
in
alleged
charge.
contemners. Here is my affidavit of service.
I am for the contemner number 3, my lord.
Your Lordship, kindly go through the
Thank you.
order, the last passed by your Lordship.
PSC.
তুমি কি?
আমি ক্লাব
Club.
হ্যাঁ তারা জানে কি জানে
এই স্লিপ দাও তো একটা।
Private parties.
But now I appear for the
No, I am for the private
alleged contempt number 2, the then officer in charge of Pujali police
Yes,
station.
what do
My
you
lord, I
say?
am praying for 1 week's time, my lord. Yesterday I got the brief in the evening.
No.
My lord,
My lord, they are the
kindly give
whole,
me 1 week time, my lord. I have
That's
to
the problem of your client.
and my lord,
They
this,
should have briefed you earlier.
and this private respondent, my lord, this is a club guided by a particular political party. They are raising objection. But so far as the my client is concerned, my lord, subject to correction, my lord. But I was the officer in charge. Now, my lord, I have been posted to, my lord, I cannot take the alibi. But my lord, what has happened, my lord,
So, Manager, please take the microphone. Yes.
Lordship's order is very clear because my throat is choked. My lord,
No, that's why take the microphone.
I'm very grateful to your lord.
Yes, yes.
But what has happened, my lord? So far as my part is concerned, my lord,
Mr. Banerjee, your voice is choked with emotion or due to a cold?
no, my lord.
Because you are appearing in a contempt.
Actually, my lord, I have been suffering since long, my lord,
Wow.
for pharyngitis. My lord,
Yes,
no
yes.
emotion or promotion, my lord.
No emotion or commotion.
No. Lord,
Very good,
my
yes.
lord, so far as my client is concerned,
Yes.
Lord, your lordship's direction, if any well, obstructions or something like that,
Right.
but the electrical authority will approach for police assistance.
Yes, yes.
But so far as my instructions concerned, there was no approach
No approach.
for assistance. Lord, I am ready. I am ready, my lord. Your lordship kindly takes give them time, but I am ready because but today, my lord, I have been transferred, but the officer in charge who was there.
Very well, I get it.
Yes, my lord,
Mr. Rai, why you didn't approach?
The occasion has not arisen as yet, Lord. Kindly take note page 45 of the contempt application. टेनिए नीचे वाला।
बोल के दाঁড়াও, আমার দিক না।
Yes, my lord, page 45 is the offer letter, my lord, which we, my lord, CSC Limited, my lord, gave to the petitioner.
Yeah.
The lordship will kindly think, my lord, the compliance is to be met. Kindly see, my lord, the second compliance. Have the meter board shed built or extended as is directed. My lord, when we had gone for inspection, my lord, on 22nd of April 2023, my lord, we found that the meter board shed was not constructed. My lord,
That is because of the resistance created.
then that
Sorry.
resistance, my lord,
Very well. You take instruction, come back. Yes, you can submit. Yes. If you're ready, you submit right. Yes.
My lord, I have to take instructions, my lord. Yesterday I got it, my lord. That is why, my lord, I started, my lord, with my submission that I have.
Learned counsel appearing for the alleged container number 2, comma, the concerned police officer at the relevant point of time, comma, submits that the police is ready and willing to provide police protection if so sought by the CSC Limited. However, comma, since no such help was sought, comma, there arises no occasion for the police authorities to have given such help. Next parallel, counsel for the CSC Limited submits that unless a meter room is built stroke extended, comma, the electricity connection cannot be given to the petitioner. It transpires from the order dated February 2, 2024, passed in the contempt application, that a similar recording finds place in the said order. Next para, it was alleged by the petitioner that the private respondents are creating obstruction in implementation of the order of this court, even to the extent of resisting the extension stroke construction of the meter room. Learned counsel having instruction to appear for the private respondent stroke alleged contemners.
My container number 3, my lord.
That is as a private respondent stroke alleged for passing further order.
But only, my lord, subject to
Affidavit of
correction.
service file to be kept on record.
Well, may I seek one indulgence? Because since, my lord, I have been transferred to, my lord, Uttarpada police station, my lord, the new inspector in charge may be
Mr.
added.
Banerjee, please give the name or details, the name of the present incumbent, he will add.
Name, my lord, I can, my lord,
Then how can they add?
no, my lord, tomorrow, my lord, but
You are
in
not
course,
on contempt till
no, in course of day, my lord, I will give.
We want to take electricity, my lord.
Arey baba, no,
Not to put
that I'll
anyone.
do on the next date if necessary. Otherwise, you are not.
no, my lord, only, my lord, because if they, my lord,
By
authority,
direct personal appearance, I'll keep it in mind.
my lord, authority, my lord, sought for permission.
Whichever officer Mr. Banerjee resides closer to the court, I'll direct him to appear. The present incumbent or the previous one. No doubt on that.
No, what is actually subject to correction? But if not authority in the meantime sought for permission, he cannot take
Whoever
permission.
is there will give the case.
Yes, that's why lordship kindly make it clear.
Need not. In the
Make it clear.
Item number 16.
Get full.
কত এটা? 16 Mr. Banerjee, yes.
Milord, the writ petition was against Milord unauthorized installation of a lift. Milord, our allegation was that Milord, by a communication, the chief electrical inspector Milord had said that Milord, no sanction is required, which was wrong. My lord was pleased to hold Milord in the judgment Milord delivered by your lordship, which is now under contempt. Milord, on 17th April, that Milord, this is wrong. And Milord, a cost of Milord 50,000 rupees was imposed upon him. Milord, there was Milord a direction upon Howrah Municipal Corporation to start Milord the demolition proceeding, because Milord, it was already submitted that Milord they had Milord issued demolition notice and all. Till date, Milord, the demolition has not taken place. No step has been taken, Milord, for demolition. The lift is being used, Milord, by Milord the private contemners, private respondents, and Milord the cost, Milord, has also not been paid.
Who is the alleged contemner?
Milord, the
No, who has to pay the cost?
Milord, the chief electrical inspector.
You are appealing for both. Chief electrical.
Services. Already BJ now he is the commissioner. He was the commissioner 5 years. That is this. Already we have taken steps. Our engineer have taken steps. We have given issued notice, and within 2 weeks or 3 weeks we will demolish the entire construction matter, because we have already issued notice.
You have served properly on the electrical inspector also?
Yes, Milord, but Milord, we have served upon Mr. Krishna. Milord, now
Mr. Krishna is a commissioner.
Yes.
That I will take care of that. I'll record that.
And Milord, Shabai service.
No, I'll take care of that.
Everyone has been served, Milord. Here is the service. Milord, I have not personally checked, Milord. Mr. Banerjee says.
I'll give you
May I interrupt, Milord?
time to do that.
3 weeks time, Milord.
3 weeks time. I'll record your submission.
Milord, may I?
That also I'll do. Please,
Because he is taking all
please,
steps.
please give the name, the current income.
Milord, may I interrupt?
Appealing for the- Yes,
Milord, I'm in this matter, Milord,
for whom?
for respondent numbers, alleged contemner numbers, Milord, 5 and 6.
There are no 5 and 6 contemner.
But contemner number, the respondent, contemner numbers 3 and 4, Milord.
Electrical inspector.
Who are using the list?
Yes.
No, Milord, the persons, Milord, against whom?
Yes, after the demolition, I'll hear you.
Milord, my lord's order, my lord, my clients have, my lord, carried on, my lord, an appeal, my lord, from my lord's order, my lord. And my lord, by an order dated 6th of July 2023, my lord, my learned junior is there, my lord, the Miss Hardika Rajdev. She has a copy of the order, my lord. My lord, by this, my lord, I have contended before, my lord, the Honorable Division Bench, my lord, that the notices to which my lord has observed that the corporation should take steps, my lord. My lord, there was a writ petition, my lord, filed challenging those notices.
The other side also. Give it.
Yes, my lord. My lord, there was a, my lord, writ petition challenging those notices, my lord, which was firstly, my lord, disposed of, my lord, directing the corporation to take steps for demolition by a coordinate bench, my lord. Thereafter, in an appeal, my lord, carried out, my lord, before the division bench, my lord, that order was set aside and the single bench was directed to, my lord, reheard the matter on exchange of affidavits. Now, my lord, on this apprehension that during pendency of my writ petition, my lord, by dint of my lord's order, my constructions will be demolished, my lord. The division bench, my lord, has, my lord, said that, my lord, that was a mere observation. Even if my lord, if sees my lord's order, my lord has only, my lord, said that it is expected that the Howrah Corporation shall take immediate steps for carrying out the demolition work in due process of law. My lord, the division bench, my lord, by this order, my lord, has clarified that was a, my lord, mere observation, my lord, and in case, my lord, there will be any difficulty or if my apprehension, my lord, that it's gonna be demolished, my lord, I can, my lord, file an appropriate application, my lord.
The order
Yes,
of
with
No, my order was an interim order.
No. Final judgment
No.
and order.
My lord's order for which contempt has been complained, my lord, that order was, my lord, challenged.
That
4013 was the writ petition out of which, Milord, this contempt application arises. And Milord, this order, Milord, speaks about, Milord, second.
Yes, different.
And
No,
my
no,
lord,
this has no connection with that.
and my lord's order is not touched even.
No, my lord's order 17th April 2023, my lord, for which, my lord, now, my lord, this contempt application has been filed. This order was, my lord, was challenged. Kindly see the second paragraph, my lord, of the order, which
No, no,
was
you have
handed
filed
over, my lord.
Go and file a stay application in connection with 15143.
My lord, kindly considers, my lord, the notices, my lord, I have a
Pal, have you filed any application in pursuance of this order in WPA 15143? That was the liberty given to you. Have you done
no,
that?
my lord, I have not filed.
Very
No,
well.
my lord. Why, my lord? Because the, my lord, division bench, my lord, kindly, my lord, the division bench was of the view, my lord, that the, my lord, the by the order passed by my lord, that was a mere observation. And my lord, in case, my lord, I will feel any apprehension that that's going to be demolished. And even, my lord, the corporation was represented, who has taken the same stand before the court, my lord, that since the writ petition is pending, my lord, where, my lord, the correctness of those notices, my lord, are challenged. My lord, kindly considers the writ petition was firstly allowed, my lord, directing demolition, my lord. Thereafter, my lord, the division bench, my lord, was pleased to set aside the order, my lord, saying that that will be decided. My lord, kindly
Pal, I've heard
consider
you
the
sufficiently. Learned, yes.
Then
Learned, right.
We want an indulgence, my lord. The appropriate police station to help us because assistance should be given to us because serious
Learned,
violation will be raised.
very well. Learned
my
counsel.
lord, my lord, one thing, my lord, if my
Paul,
lord, so
I'll don't compel me to
pray for my lord's leave, my lord, my lord,
don't
one thing
compel
only,
me
my
to
lord,
shut off your microphone. Please stop now.
only one thing, my
Counsel
lord.
for the alleged container number 1 submits that the person named as alleged container number 1 has demitted office long back as footstep as such, comma, the present incumbent should be impleaded. Footstep. Learned counsel for the alleged container number 1 is requested to furnish the name of the present incumbent to his counterpart appearing for the petitioner within a day. Footstep. Necessary consequential corrections shall be carried out by the petitioner to the contempt application, impleading the present incumbent in place of the alleged container number 1 named in the contempt petition before the next returnable date. Footstep. Next para. Immediately after that, comma, the alleged contemner shall serve a copy of the contempt of the amended contempt application on the learned counsel having instruction to appear for the alleged contemner, who is requested to receive the same on behalf of the newly impleaded incumbent.
Shall be, it will be, मतलब shall be served.
কি বলেছি?
ঠিক আছে।
Thank you. Footstep. Next para. Learned counsel appearing for the alleged container numbers 3 and 4 places reliance on an order passed by a division bench in an appeal carried against the parent order dated April 17, 2023, passed in WPA 4013 of 2023. Footstep. It transpires from the said order that the division bench had disposed of the said appeal by giving liberty to the alleged container numbers 3 and 4, comma, who had the appellants therein, comma, to file a fresh application for stay or injunction in a different writ petition, that is WPA 15143 of 2022. Footstep. Next para. The premise of the division bench was apparently that this court had expected that the Howrah Municipal Corporation shall take immediate steps for carrying out the demolition work in due process of law pursuant to the demolition notices issued by the corporation in respect of the elevator in question. However, comma, the observation of the division bench to that effect, in that regard, was that sufficient remedy would be available to the appellant therein to file the fresh stay or injunction application in WPA 15143 2022. Footstep. Whatever may be the premise of the said order, comma, the fact remains that the order passed by this court was not interfered with, comma, which clearly indicated that the Howrah Municipal Corporation was to take immediate steps for carrying out the demolition work in due process of law pursuant to the demolition notices. Full stop. Next para. And within double inverted expectation, double inverted of the court carries the force of an order, and as such, comma, the interpretation sought to be lent by the alleged container numbers 3 and 4 to the same cannot be accepted. Full stop. That apart, comma, the expectation in question was correlated to the already existing demolition notices issued by the Howrah Municipal Corporation in respect of the elevator in question, comma, which still remain. Full stop. Next para. Learned counsel appearing, having instruction to appear for the alleged container number 1, assures the court that he has instructions that the present incumbent of the Howrah Municipal Corporation shall take immediate steps to ensure has already taken shall take na, has already taken steps for demolition of the elevator in question. Full stop. It is submitted on instruction that the demolition process shall be completed expectedly within 3 weeks from date. Full stop. Next para. In view of such submission, comma, the matter is adjourned till March 22, 2024, when it will be listed under the same heading for passing further orders.
Should I?
I've given you 4 weeks. I've kept it 4 weeks after. As a police.
Because they will disturb us.
But that will be modifying the initial order. Anyway, I'll put something in it. Learned counsel for the alleged contemner, comma, it may be mentioned, comma, expresses apprehension of resistance in the demolition work, full stop. However, comma, even under the general law, comma, the local police station is in charge of taking care of law and order situations in such scenarios, full stop. Since the Howrah Municipal Corporation is a government instrumentality, although an autonomous body, comma, it is always at liberty to approach the concerned police station if it has any difficulty in implementation of any of its demolition notices. Full stop.
That is there in the statute. No.
Exactly. Hence, comma, the alleged container number 1 shall be at hence the Howrah Municipal Corporation shall be at liberty to seek such protection from the concerned police station if need be.
Should I submit a further notice upon the chief electrical inspector, because he chose not to appear when the writ petition was heard? My lord was infuriated, which is expressed in the
Arekta line add kore daw. It must further be noted that despite service, comma, which alleged contemner 3,
2.
The alleged contemner number 2, comma, who was directed to pay costs of rupees 50,000 is recalcitrant in his attitude, inasmuch as he does not care to be present or be represented today when the matter is called on for hearing. Full stop. You have checked up good service has been affected.
I will personally once again.
Affidavit service check up.
এক minute. নামটা কি?
As a last chance to the alleged container number 2, comma, he is permitted to appear to be represented on the next returnable date, full stop. In the event he chooses not to do so, comma, a rule may be issued to ensure his personal presence on the next returnable date, full stop. The learned advocate for the petitioner shall communicate the gist of this order coupled with a server copy of the same to the alleged container number 2 to ensure compliance.
Grateful, man.
And file an affidavit of service to
Yes,
that effect as well on the next date of hearing.
Yes. Great.
What?
Server copy can be received by Monday.
Yes, yes.
It's a very big order, so
Right.
That.
Very
Great.
server copy. I'll sign today. It should be on the server by tonight. Should be.
Item number 17.
Sorry.
My lord, I will arrest one.
Yes.
The
last petition, my lord, I have submitted it.
Lord, I am appearing on behalf of the writ petition in this matter.
You have to file reply.
My Lord,
Won't file.
this is a changed brief to me, my Lord. I have accepted it day before yesterday, but I have gone through it. My Lord, it does not require that I should file any reply. I have very minutely gone through the affidavit in opposition. She has expressed such difficulties that for what reasons she is not in a position to comply with the order. Lord, my submission before Lordship is this, Lord. I do not want to, Lord, lengthen this matter and go for litigation after litigations. Lord, your Lordship's order dated 29th of August 2023 may be complied with. And I have gone through very minutely with by your Lordship's order. And I have found that your Lordship could visualize the situation that this may arise. So your Lordship has given the enough protection and the orders have been passed upon the authorities concerned that you comply with the order. If there is any difficulty, take the assistance of the district magistrates. These things have not been
And
done.
in plain English, what has been done? What does that mean?
Lord, they have not done anything. They say that there is water in the plot. There is jol. Lord, Lord, your Lordship knows, Lord, that in village areas that water has accumulated. And she has said in her affidavit of opposition that jol will dry up in the month of March and April. And after drying off the jol, Lord, she will supply the electricity. That is her submission in her affidavit of opposition. That is at
But
page
you have to
7.
explain that in your reply. An opportunity was given to you to file reply. You have to explain that in your reply.
Kindly gives a short date, then 1 week, Lord, because I do not want to linger the matter because they have been suffering.
My lord,
Now, how do you want me to dispose it of? Don't want to linger means I'll dispose it of. In what manner?
Lord, in the manner that order should be complied. If she requires
After the water is dried up, they will give the connection. That will do.
she has said so. She has said so in her affidavit in opposition.
So with that, I can accept that. And
yes, submit, my lord.
yes.
Kindly, my lord, see your Lordship's order at page 27. Para 23 and para 25, my lord, 2 times mentioned that subject to compliance of all formalities.
Yes, definitely.
Yes.
But
Has to be.
till date, he has not complied the
What is the
What are the
non-compliance?
formalities?
Please.
Lord, take first.
Let her speak now. Yes.
My lord, he made application online. And I have annexed it. Page
Ms. Right,
7,
tell me what he has to do now.
the occupancy certificate, and we have written him, page 10, that please submit the relevant documents. But till date, he has not complied with it.
Page 10 of the opposition.
Yes, my lord.
Page 10.
Page 10.
10 is only way leave certificate.
Well, it's certificate relevant documents, and my lord,
What are the relevant documents? You have not disclosed.
submit the relevant documents of land as well, no objection certificate.
Why is way leave required? Was not a direction given specifically to give connection? I'm just
Page 11 to page 16, his
Right.
online application. Page 14, blank, my lord.
no, Ms. Rai, you are given liberty to approach the police if necessary.
Yes, after compliance of all.
So where is the question of further way leave certificate?
My lord, page 13, my lord, kindly see blank. Page 14, blank. Page 15, illegible. It is not proper. I have not find anything. And page 16, that is Shochindranath Maiti. His name is Eknath Khan. He has submitted the document, Shochindranath Maiti. In spite
Yes,
of
what
that,
do you say?
in spite of that, my lord, your lordship's order, we went to that spot with technical team, and we found that the complete area is surrounded with water. Immediately, we wrote another letter, page 7.
You have to produce the necessary documents first.
Lord, give me the liberty to file the reply. Lord, I shall put on all the things.
The affidavit in opposition, it transpires from the affidavit in opposition filed by the alleged contender number 1 that the online application filed by the petitioner is deficient on several scores. Full stop. Apart from no occupancy proof having been given by the petitioner in his own name, comma, certain portions of the application have been kept blank. Full stop. Next para. That apart, comma, it is contended that due to the area being covered by water, comma, the connection could not be given to the petitioner. Full stop. Next para. Learned counsel for the petitioner, comma, who is appearing on change, comma, seeks a further week's time for filing his reply. Full stop. Accordingly, the time for filing affidavit in reply is extended for a week from date. Full stop. The matter be listed on March 1, 2024. Full stop. Please take care that all these problems are also resolved by you, because from the form it appears it is not proper.
Name of the alleged contemner is Arvind Sharma, but it is written here Arvinda.
I'm not
Delete the
Bengali. What is Arvind? Arvind Sharma.
I'll give you liberty to. আরেকটা line add করি, leave is granted to the learned advocate on record for the petitioner to carry out the necessary correction to the name of the alleged contemner as per the correct name supplied by learned counsel for the alleged contemner number 1. Ms. Rai, please just give the exact spelling.
I'm requesting her to write the name correct because you still লিখে দিন আপনি।
Next.
Item number 18.
Yes, my lord.
এটা কারেকশন করে দাও বুঝেছো?
My lord, I have complied the direction of the court, gave them a copy of them. This is the affidavit of service. Before filing this petition, lawful petition, I gave them a notice of 30 days for reply and objection if they have any. But they did not give any reply and objection from their side. After that, the contempt petition was filed before this learned court for waiting for justice. Kindly allow the petition for the sake of justice, my lord.
What is the order? What is the violation?
My lord, they did not comply the direction of the court. They did not give information in regard to each and every matter. And as you said, to give to him the response in each and every matter within a specific time period.
Please show me that direction first. Which
My
page?
lord,
My order is at which page?
My lord, I forgot to bring the contempt petition copy today. It is in my
I'll check up. I'll check up. Wait. But you have to, yes. Affidavit of service filed today be kept on record. Full stop. It appears that despite service, comma, the alleged contemner is not represented in court today. Full stop. Next para. A prima facie contempt of the order dated July 14, 2023, passed in WPA 14753 of 2023, has been made out inasmuch as the respondent stroke first authority was directed to give a response to the query made by the petitioner under the Right to Information Act 2005 within a week from that date. Full stop. It appears from the averment of the contempt application that such reply has not yet been given by the alleged contemner. Full stop. Since the alleged contemner chooses to remain unrepresented despite service, comma, a rule be issued directing the alleged contemner to show cause as to why penal action shall not be taken against him for willful and deliberate violation of the order of this court dated July 14, 2023, passed in WPA 14753 of 2023. Push up. The rule shall be made returnable on March 22, 2024, when it will be taken up at 10:30 a.m.
Thank you, my lord. Thank you very much.
Mr. Gop, you have to put in the requisites for issuance of the rule. Please inquire from the department what requisites you will have to put in. You will have to put in some nominal amount of money for issuance of the rule through court. Rule will be issued through court. Ask from the department what you have to do. Yes.
Item number 19.
My lord, I am for the petitioner, my lord. My lord, this is my affidavit of service, my lord.
Right.
My lord, this is the contempt of your lordship's order dated 9th October 2023, my lord. When your lordship's directed the respondent number 3 to consider my representation. First, there are two directions, my lord. To consider my representation and to hand over the deeds which they have taken at the time of obtaining loan.
What is the order? Which page?
My lord, that's a page 17, my lord, subject to correction of the contempt application.
17.
17, annexure B, my lord.
Achha.
My lord has got it. After the copy of the writ petition, my lord, subject to zero sum.
No.
Order dated 9th October 2023.
Neither at page 17, not at page 70.
Well, after the copy of the writ petition has
এটা
been
দাও
annexed.
না দাও যেদিন
No, what about the copy of the writ
immediately after the affidavit page দাও দেখি No, this is
Immediately
something else synopsis দাও দাও দাও
If your lordship kindly hand over, my lord. Sorry. Okay.
Is that the synopsis of my order?
Yes, my lord.
It's written synopsis. I don't know what it is.
No, my lord, synopsis of the writ petition, my lord. না না এটা আমি বলছি ওটা পরে
You found it out, Mr. Abdul?
Yes. Actually, the writ petition was subsequently annexed, my lord. That is why there is difficulty.
They have not decided.
My lord, what has happened, my lord? Representation has not been considered, but in the representation, my lord, there are twofold submission that to refund my foreclosure charge and to hand over the deeds.
Subject to payment of all dues of the bank by the petitioner.
That is no dispute, my lord. Payment has already been made. No dues.
Let me ask Ms. Ghosh. Yes, Ms. Ghosh.
The payments have already been made. Your lordship, the first thing what has been just been submitted, relying on the representation when your lordship had passed the order, subject to payment of all dues of the bank by the petitioner, the respondent number 3 is also directed to return all the title deeds of the petitioner within 4 weeks from date. And your lordship, the same was to consider the representation of the petitioner as annexed to the writ petition. Your lordship, in the writ petition, your lordship, if I rely on all the communications which my learned friend has referred to, your lordship, in accordance with that, your lordship, all amounts have been paid by him. The foreclosure charges have been entirely returned to him. And with regard to the deeds, he was asked to come and collect the copy of the deeds. And that he has also stated in the contempt application.
So there is no impediment now to give the.
We are returning all the deeds. Now he is raising a new issue, which is not even the subject matter of the representation.
What is that issue?
That the deeds do not have the copy of certain documents. That is a
No, my lord. Only one thing, my lord. My lord, I am submitting a lordship, my lord. When they have given the mortgage, my lord, they have accepted some deed. My lord, deed contains a plan, which is not in the deed. My lord, this deed must contain a plan. But that are specifically accepted. They have they are finding out. No, my lord. They are stated that they are finding out the plan, but never said. Let them consider the representation that we have not submitted the plan. That was my lord's order. Consider the representation. In the representation, if you lordship kindly see my copy of the petition, my lord. My lord,
I mean, these are the list of documents. We cannot go beyond this.
Yes, my lord, the copy of the deed is there, my lord. My lord, map is the part of the deed. They have accepted. Map is a part of the deed. My lord,
accepted. Where is the acceptance?
My lord, that is acceptance, my lord. You lordship kindly see.
See what?
My lord, I am submitting. Well, that is the first page, first annexure of the petition, my lord. Well, this is the first annexure of the petition, annexure P1, page 13, my lord. Annexure P1, page 13 of the petition.
Yes, title deeds.
Yes, my title deeds must contain plan. Let them say that we have.
But I don't know. How can I know title?
Well, let them say, my lord, when your lordship is directed or consider the representation.
You take whatever documents they give. Sir Gupta, you take whatever documents they give. If you have any objection, give it in writing. They'll accept that.
My lord, give it in writing, my lord. I have given in writing as per my lord's order.
Contempt, we cannot go further.
My lord, your lordship cannot. My lord cannot go into that. My lord, your lordship cannot go into that question. But your lordship's directed to consider the representation. My lord, specifically stated that please return the deed with annex map.
With annex map, where is that written?
Yes, my lord. My lord, I'm giving your lordship, my lord. I'm giving your lordship.
Page 13 of your writ petition does not mention any map, Mr. Gupta, subject to correction by you. It only speaks of a deed.
My lord, your lordship kindly see annexure P2, page 58, my lord, of the writ petition. This is a representation. Well, this is the representation. You will also be directed to consider this representation. Annexure 58. That was annexure page 58, annexure 12.
No, in the writ petition, what was the page?
58. Well, after going through this petition, you will also be directed to consider the representation. Let them consider, that has not been considered.
They have considered, they're willing to return the deeds. What else will be considered?
Let them with map, it has been stated with map. Let them say that there is no map. Let them say.
They are saying that I'll record that. There is a contempt on their part.
Your lordship, kindly see, they are saying that they are finding out. They are trying to find out.
Affidavit of service you are filing today.
Yes, ma'am.
I'll drop the contempt.
At least your lordship kindly.
I'll give you proper liberty.
Because my lord, then.
Page 1, page 6, they have also stated categorically that what are the documents. He has nowhere stated with regard to the map or.
Well, the map is the part and parcel of the document, my lord.
Your lordship may kindly consider his own statement. He's making out an altogether new case today in a contempt court.
Learned counsel for the petitioner submits that although the alleged contemner sought to return the deeds of the petitioner, a map annexed to a particular deed, which was a part of the deed, is not being returned by the alleged contemner. Next para, learned counsel appearing for the alleged contemner places reliance on the averments in the contempt application itself and the relevant documents of mortgage, which indicate that certain original title deeds were inter alia deposited with the bank by the petitioner. There is no mention in any of the concerned documents as to whether any map was or was not a part of such title deeds. Since the alleged contemner is willing to return the title deeds to the petitioner and the petitioner has raised a new question as to whether a map was a part of one of the deeds or not, the same cannot be decided within the limited conspectus of the present contempt application. The order of the direction of this court was for the alleged contemner to consider the representation of the petitioner and to return the title deeds of the petitioner subject to clearance of all dues by the petitioner. Since the alleged contemner is of the opinion that all dues have been cleared by the petitioner and takes a specific stand that whatever title deeds are lying with the alleged contemner shall be returned to the petitioner, but the plan alleged by the petitioner was not a part of the said deeds.
They are not saying that, my lord.
They are submitting that. I've recorded that only. Since such stand is being taken by the alleged contemner, the petitioner would be at liberty to take appropriate steps against the alleged contemner, furnishing proper proof as to whether any map was a part of the deeds lying with the alleged contemner. However, as the alleged contemner is ready and willing to return all the title deeds of the petitioner, there is no occasion of deliberate or willful violation of the order of this court. Next para. Accordingly, CPN 1709 of 2023 is dismissed. However, if the petitioner has any grievance regarding all documents not being returned to the petitioner, the petitioner would be at liberty to approach the appropriate.
My lord, only one thing, your lordship, instead of dismiss, your lordship, kindly make it
Contempt has
disposed
to
of.
be dismissed.
My lord,
No willful violation of.
No, that is true. My lord, another thing, my lord. So far as the foreclosure charge is concerned, my lord, they have refunded, they returned, my lord. That your lordship kindly recording.
What has it?
Foreclosure charge, my lord. That was all.
I've only directed the title deeds to be.
No, my lord.
Anyway, there is no contempt. That is what matters in a contempt application.
My lord,
there is no willful.
My lord, instead of dismiss, your lordship kindly disposed of, my lord.
Only spelling difference.
My lord, your lordship.
Next matter.
Item number 20.
Yes. Yes, Shakot, what is
Your lordship, my lord, I beg to appear on behalf of the petitioner. My lord, kindly recall this is a matter relating to the the pensionary benefit of the employee of the health department. And the last occasion, my lord, what happened? Lordship was kind enough to direct us once again to go there and to, my lord, submit, deposit all documents which are lying with us. Though we have, my lord, submitted on number of occasions to them, even after the order passed by this honorable court, at least 3 occasions they have invited us to produce all those documents. Again, we went there and produced it. At the time of production document, my lord, kindly see, my lord, this gentleman who is, my lord, the director of the health service misbehaved with the learned advocate, which I, my lord, on the last occasion, I have made that allegation. Lordship was kind enough to direct, my lord, the state authority to come back with a satisfactory explanation. My lord, they have denied it. Lordship, kindly see, my lord, this explanation in the form of affidavit in opposition. My lord, they have served as a copy. My lord, same thing, my lord, last 7-8 years, repeatedly asking for same document, though they last, my lord, in the year 2011, rejected our contention for compassionate appointment, referring to 3 file, my lord. Kindly see, my lord, paragraph. Before that.
Paragraph 6. No, let
Yes, yes,
yes,
yes,
of course. Yes. Paragraph 6. Yes. কত নম্বর থেকে ঠিক আছে What is the exact reason why? Let us forget the allegation. What is the exact reason for which it is not being given to them?
Regarding the papers, no paper is there. Here is the kindly see me, Lord. Here is the notes of the file.
Mr. Chakraborty, I'll file a reply to this.
True,
File a
madam.
reply to the annex, all the copies of all documents which have been handed over by you.
Lordship.
We'll satisfy ourselves on that
And
and
Lordship,
issue a rule of
while passing order, Lordship was kind enough to take into consideration each and everything. My lord referred section 106 of Evidence Act, 114
not
of the.
only Mr. Chakraborty, they are taking specific stand
Yes,
that
my
you have not given all the documents.
Yes, my lord.
Have you taken a receipt when giving those documents?
Yes, my lord. The document which are lying with us, they are repeatedly directing us, my lord, to show my appointment letter. Last pay certificate. This was, my lord, deliberated in the State Administrative Tribunal, Division Bench, everywhere. And thereafter, they have committed to reconstruct the file. In the year 2011, my lord, lastly, they have rejected our contention for compassionate appointment by referring to file. Lordship, kindly come to, my lord, supplementary
Yes,
evidence.
all the documents must be with you.
Yes. Yes.
That is the problem. There is no document. This is the case of the last 60 years back, my lord.
Give the money to them. If you don't give it in the normal process, then I'll resort to abnormal process.
My lord, kindly speak.
Your director, who is the
My lord, here the director.
who is the contemner?
My lord, the contemner here, my lord, director of health service. Lordship, kindly see their affidavit.
Come to court and explain.
He is, my lord.
You are not being able to explain properly for him. Let him come himself and explain.
Well, he is 66-year-old, my lord. He is blessed by the authority, as a result of which he dares to, my lord, violate the order of this constitutional court.
To file a reply to this.
Yes, my lord, I will file.
Have a reply
At the same time, my lord, one indulgence led by the principal secretary of the health department being, my lord, directed to look into all issues. These gentlemen,
Mr. Chakraborty, directions have been passed.
Yes,
we
my lord.
exhausted the stage of
Yes,
direction.
yes, my lord.
We'll pass different orders. now.
Lordship.
But file a reply. In that
Yes, my
reply, I'm indicating that please annex all the documents which you produced.
Yes, my lord. By way of supplementary affidavit, last occasion we have produced all those documents that is lying in the record also. Apart from this record, I have got no other document. Lordship, kindly see that supplementary affidavit, a big bunch, voluminous document. Lordship will find the last, my lord, the 2 year back, my lord, I have filed it.
Right, Pritham. Supplementary affidavit.
Supplementary affidavit. What is their statement before the State Administrative Tribunal? We want to reconstruct it subject to the permission of the authority. This bunch. Possibly kindly see, my lord, 102. My lord. This is the order in portion of order of the Honorable State Administrative Tribunal.
Yes.
My lord, after 5 line, my lord, referring to the reply filed by the state respondent, particularly in paragraph 15 thereof, it is submitted that since the service book of the disease is not available, no new service book has been directed to be reconstructed due to lack of instruction from the higher authorities. And as it is evident that if directed, service book can be reconstructed. This is one aspect, my lord. Then, my lord, I am drawing lordship attention. Page 138.
138?
Even in the year 2011, they have denied, my lord, compassionate appointment, taking the plea, but a long time have been elapsed, as a result of which this cannot be granted. Referring to 3 file number. Page 138, my lord.
Yes.
My lord, 138, my lord, I am reading the letter. In response to the above mentioned memo, the undersigned would like to inform you that the instant case has been in a file bearing number so-and-so of 2009 of the office, from where it reveals the prayer of the applicant has been rejected by the memo number so-and-so of 2011, 9/8/2011, on the ground of submission of prayer and ex-employee died in harness, and my lord, thereafter compassionate employment offer after a long gap of 25 years. Even 2011, they are maintaining their file. That being the situation, and here this gentleman who is blessed, my lord, at the age of 66 years, he is doing work. He has taken the same plea, no document, nothing of this sort. We have handed over all the documents which are lying with us on repeated occasion since, my lord, State Administrative Tribunal up to this, my lord, on the last occasion.
You took a stand that there is no new service book has been directed to be reconstructed due to lack of instructions. Now that was the point taken before the tribunal. They have handed over all documents. What other document they have?
No document they have. Where is the document? We have no proper document. There is no appointment letter. There is no joining letter. There is no GPF.
In your opposition, in your opposition, have you enumerated what are the documents required? Let me see that.
Yes. Page number 5, Milord. Everything is clear. Page number 5 of the affidavit. Affidavit of opposition.
Yes, page number 5. What are the exact documents required? Tell me. Read the relevant portion.
This is a file noting of 2021. After the order passed by this honorable court, nothing done.
No.
Yes, what are the documents required?
Documents, appointment letter.
Where is that? Where do I find that? Where do I find that? Have you stated anywhere?
Yes, Milord.
Where? Show me. Mr. Chakraborty, did I consider this in my order? Just show me from my order that these documents were with them or something like that.
No, my lord, our humble submission, Lordship was kind enough to look into all the issue. My lord, kindly see the contempt application page.
There must be some indication in my order.
Yes, my lord, I am showing, my lord. Page 20, paragraph 12 onwards of, my lord, the order passed by this honorable court that is available in the contempt application.
Yes, that was para 1920. These were clearly.
Yes, my lord. And my lord,
these were clearly considered in para 1920.
Yes, my lord. My lord, this honorable court was unambiguous, my lord, directing the authority to disburse it, my lord.
No, I'll issue a rule of contempt.
To disburse it, my lord.
Please
Paragraph
come to
30.
the order of this court, the parent order. Please come to the parent order, sir. Please read para 1920 onwards. You took the same point there, same point before the tribunal. Everywhere you took the same point. A lame excuse, which was dealt with. This court held that there are two indicators in the materials of record which favor the petitioner's claim. First is communication by the Director Department of Health, dated August 2nd, 1984, which indicated that deceased Shochipati died in harness. Second, in a reply to the Member Secretary of the West Bengal Women's Commission, Joint Director of Health Services Personnel wrote on 28th May that compassionate appointment prayer of the petitioners was rejected in view of the delay in finding the same. In the same breath, observing that late Shochipati was an employee who died in harness on December 28, 1981. Your admission. Para 20 says the petitioners, who were quite young at the relevant juncture when Shochipati was in service, and even when he met his demise, cannot be expected to be in custody of relevant papers regarding the service of Shochipati. So they were absolved of that liability. Insofar as the burden of proof is concerned, it is the employer of Shochipati who ought to have special knowledge regarding Shochipati's continuance in service. In the present case, special knowledge lies with the employer. Therefore, in this context, you are directed to pay. They don't have to give a scrap of paper. You have to pay, sir. I'll issue a rule against your director, whoever.
Milord, kindly give me, Milord, a week time, Milord.
No further time. No. You are playing with the court.
No.
Not you, I mean, your client office.
Milord, kindly.
Now let the court play with your client. It's high time we do that. So see, if some of these officers are behind the bars, that will be the only lesson, because you take contempt too lightly due to our lenience. It's our fault. Let me rectify that fault now.
Milord, kindly give me a time.
You will be an example. No further time. Sorry, I'll issue a rule. You'll have to be personally present.
Milord, kindly give me
The affidavit in opposition filed by the alleged contemner today be kept on record. Full stop. A blatantly lame excuse is taken there, comma, to the effect that the petitioners have apparently failed to produce relevant documents, comma, for which the pensionary benefits could not be released in favor of the petitioners. Full stop. Next para, learned counsel for the petitioners rightly points out that the same excuse had been taken time and again by the alleged contemner before all the authorities, comma, which culminated in an order of this court, comma, which is under contempt. Full stop. Next para. In fact, comma, in the order of this court dated August 21, 2023, comma, in particular in paragraph numbers 20 onwards, comma, it is clearly mentioned that the petitioners were quite young at the relevant juncture when Sochipati was in service and met his demise, cannot be expected to be in custody of relevant papers regarding the service of Sochipati. Full stop. It was also recorded in clear terms that the burden of proof is on the employer of Sochipati, who ought to have special knowledge regarding Sochipati apostrophes continuance in service with the said employer or otherwise. Full stop. The heirs of the deceased employees, comma, it was held, comma, were not expected to carry documents regarding such service. Full stop. The inability of the employer to produce service records all along, at least since 1983, comma, it was observed, comma, cannot be justified in any manner. Full stop. It was also clearly recorded that Sochipati apostrophe's service was admittedly continuing at least till May 18, 1965. Full stop. In normal course of things, comma, the said service would continue to subsist till his demise in 1981. Full stop. It was also observed that in the absence of any material to show that late Sochipati was ever suspended, comma, retrenched, comma, dismissed or retired from service before his death, comma, the petitioners are definitely entitled to the entire pensionary stroke retirement benefits due on the demise of their father. Full stop. Only in the light of such observations, comma, WPA 21887 of 2022 was allowed on contest, directing the respond number 7, comma, the special officer within bracket pension bracket closed, Government of West Bengal, to disburse the entire retirement stroke pensionary benefits of late Sochipati Ghatak, an ex-employee of the Katwa Subdivisional Hospital, comma, Poschim Bardwan, Poschim Bardhaman, comma, calculating such pensionary benefits by applying the appropriate scales for the period till the demise of late Sochipati on December 28, 1981. Full stop. Such disbursal was to be effected within 2 months from the date of communication of this order to the respondent number 7. Full stop. Next para. Hence, comma, in view of the said clear and transparent observations in the order under contempt, comma, there remains no doubt that the entire burden of finding out or reconstructing the records was on the alleged contemner. Full stop. Having not done so, comma, the alleged contemner merely projects the same lame excuses which have been used all along by the said alleged contemner to bypass the legitimate claims of the petitioners. Full stop. Such recalcitrant attitude is blatantly contumacious, and as such, comma, the alleged contemner is required to personally be present and answer the court why he should not be committed to prison or fined for the deliberate and willful violation of the order of this court. Full stop. Accordingly, rule do issue calling upon the alleged contemner to show cause as to why the penalty in terms of the prayers made in the contempt application shall not be imposed on him for deliberate and willful violation of the order of this court. Full stop. The matter shall be made returnable. প্রীতম আগেরটা কবে রিটার্নেবল করলাম? লাস্টেরটা ছিল আগের কোন 22 মার্চ। The rule shall next be returnable on March 22, 2024. না একই দিনে করো না। Returnable on April 5, 2024 at 10:30 a.m.
Only one indulgence. Respondent number 7 is special officer pension, government of West Bengal, and the director is, my lord, in the hierarchy above her. That being the situation, my lord.
Why didn't you make the
Yes, both of them we have implemented. Both of them.
তাহলে alleged contempt nurse করে দাও।
Contempt nurse, my lord.
Rule issue alleged contempt nurse.
And when paragraph 32 lordship
No,
was
but Mr. Chakraborty, the alleged contempt number 1 was not directly.
No, my lord, he is playing everything he is doing. My lord, can't be done. That is why, my lord, I am praying.
Affirm this opposition.
My lord, this gentleman, Director General of Director of Health Service.
Yes.
He threatened us to, my lord, to.
No, there is something on that. Might be your learned junior also said something.
No, nothing, my lord. The same paper.
Appears so.
No.
There was an altercation.
My lord, kindly see, my lord. They are asking for
there
the.
Was an altercation.
They are asking for the appointment.
Ask your junior.
My lord, I know, my lord. The client was on the last occasion here. My lord, appointment letter is nothing with us, not with us. They are asking repeatedly for the same letter.
Anyway, let us come and explain.
Deeply obliged, man. Deeply obliged. Nothing.
10 minutes for the next matter.
Deeply obliged.
Lordship, I am appearing for the alleged contemner, your lordship.
What is the
I
contempt?
appeared in person, my lord.
Yeah. What is the contempt?
Contempt was it? An order was passed on 2nd of February, my lord.
Yes.
By willful and deliberate in non-implementation of the order of this honorable court on 6th of
What is the nature
December.
of the order? They would like to refund something.
A refund of 1,20,000 rupees by the two of the contemners.
Yes, Mr. Chief.
Lordship, the thing is that the petitioner has misleaded the court, my lord. There was a specific clause in the circular which was placed by the petitioner that the petitioner
No,
has.
we cannot reinterpret
Lordship,
the order.
Lordship,
Have you
regarding
preferred an appeal?
Lordship,
And
an
did you
appeal
prefer
has
the
been.
appeal? What is the state of
Lordship,
that?
I have preferred the appeal. This is listed as item number 42 of today's list, your lordship, as specially fixed item, your lordship. We have also preferred an application for stay. Lordship, may
I'll
that
keep it after 2 weeks.
after 2 weeks, lordship, if we didn't obtain any order, if we don't obtain any order, my lord, we'll file with, we'll come back with the compliance, your lordship.
Fair enough.
My lord, there is no stay order was there passed in that
I'll
particular
an appeal for sake of judicial property. I'll give them 2 weeks.
Lordship.
And she has taken an absolutely fair stand that if they cannot get a stay order, then
I'll come
which
back
is
with
generally not
compliance.
taken.
Okay.
Learned counsel for the alleged contemner, at the outset, submits that an appeal has been preferred against the order under contempt dated December 6, 2023, which is now appearing before the appropriate division bench. Next para. It is submitted that a fortnight's time be granted for moving the connected application for stay in the appeal. Next para. Accordingly, for the sake of judicial propriety, in view of pendency of the appeal, let the matter stand adjourned till March 8, 2024.
Lordship, I'm grateful to your lordship.
Item number 22.
22 is my contempt application, coming up for the first time. The order is at page 19. The operative part is at page 20, the second and third paragraph. Accordingly, WP of 1848 of 2023 is disposed of by giving liberty.
Give me half a minute. Yes,
Yes, my lord. Accordingly, WPA 1848 of 2023 and 1850/2023 are disposed of by granting liberty to the petitioners to apply for relevant extracts of the records as well as relevant copy of the order.
So what happened? They have refused?
No, my lord. Regarding 3 queries, 8, 9, and 1, my lord, 1 has been complied with. My lord, they have submitted that one. 8 and 9 they have not given us, my lord. My lord, my application for
have they replied? Have they refused?
No, my lord. They have given the query regarding 1. The others they have not.
No reply. Learned counsel for the petitioner points out that, in violation of the order dated August 29, 2023, passed in WPA 1850 of 2023 and 1848 of 2023, the alleged contemner has not given
my application is at page 20.
Given the extracts of records in connection with all the queries of the petitioners. Since a prima facie case has been made out, the petitioner shall serve how many contemners? 1. The petitioner shall serve
1, my lord.
A copy of the contempt application on the alleged contemner, indicating that the matter shall be listed on March 15, 2024 for hearing under the same heading. An affidavit of service shall be filed on the next returnable date.
Grateful, my lord. My lord, 23 also same man.
23 or 22, 23, both separate orders koro, same order.
Grateful.
হবে না action appear করছে আচ্ছা তাহলে order for both the matters.
Item number 24.
Well, it's my petition for contempt.
Well, I am for the contempt, my lord.
Well, the order.
Being a specialist in penal consequences, 340 contempt. Yes, what is the contempt?
Well, it kindly comes to me at page 265. Well, this was the order passed by your lordship. Well, directing the ROC to take note of my final representation.
You're for the ROC?
And to rectify the records by removing Form 2 and Form 32. There are two types of forms, Form 2 and Form 32, with regard to appointment and cessation of the directors. Now, it kindly comes to page 267, the ordering part. Accordingly, WPA number such and such is allowed, thereby setting aside the communication of ROC dated 22nd December 2016 and directing the ROC to grant permission sought by the petitioner in their application, which is appearing at page 208 of the present writ petition, subject to compliance of all legal formalities and in accordance with law, in terms of the judgment and order dated 14th September 2016, passed by the appellate court in APO number such and such. Parties as well as ROC shall comply with this order on the basis of the server copy of this order. Now, kindly comes to page 208, which was the to be complied with. Kindly comes to page, it starts at page 260, 259 is the forwarding letter. It starts at page 260. These are the two bunches of Form 32, which has to be rectified. Because from a 10F appeal, Justice Sen had held that the appointments were bad. So consequently, Form 32 has to be removed. These were the two bunches, and kindly comes to page 262, the prayer portion, which had categorically stated in my lord's order to set aside the form number 32s, to set aside Form 2, to take any other steps in premises order dated that order of Justice Sen. Now, kindly takes 263, this was a reply by the ROC to my prayer. With reference to the subject cited above, your letter dated such and such, I am directed to state that upon perusal of the Honorable High Court order dated such and such, it appears that this office has not been made one of the respondent or no specific prayers upon the Registrar of Companies West Bengal in the instant. Hence, it is therefore requested that both the parties of the petition to take necessary action in order to comply with the Honorable High Court's order. This communication my lord has set aside. This is the communication my lord set aside and directed the ROC to remove Form 32 and Form 2.
So they have not done that.
They have not done. There are several representations being given after the order.
Yes, Mr. Lahiri, what do you say? What is your...
All done. All done.
All done.
Let them find the
Except. Well, I will be candid, my lord. There are two things that were to be done. One is share capital had to be reduced. And the two directors whose name has to be deleted and these people had to be done, as we incorporate. My lord, on 2/8/2023, upon getting the notice, we gave the ROC gave it to because the e-governance does it. E-governance of the Ministry of Corporate does it. We raised that by a notice that it's 16th August. The e-governance team had written to us, share capital has been reduced from, my lord, 50,000 to 20800, which will be reflected in the records, in the master data. Now, what has not been done, my lord, I will be candid. The names of the two directors, as will appear in the master data, has not been altered. But the Form 32s has been directed to be marked as defective. The two Form 32s have been
marking as defective doesn't is different from that.
Master data, master data is a ministerial act, my lord. Now, what happened? This came to the ROC from the department on 16th August 32. We thought that everything has been, because we will not check and find out that.
So, in the master data, how can the alterations be effective?
That is be done by them. We have raised two tickets on, my lord, on the 15th and yesterday. That kindly changed. No, 15th also we raised.
15th of
February. After we got the contempt petition, we thought it was done. Because it was done as early as 16th.
So how soon can it be over?
Within 1 week.
1 week.
1 week will change.
Only 1 minute. Today, just my lord, prior to matter was called, my lord, my learned colleague has taken a printout of the date master data. It's not showing defective, nothing. It's showing as good as Shankar Kumar Sharma is the director.
Just kindly tell him.
Wait till next week. We'll wait till next week. You also have your own checkup.
No. Kindly tell him to check if the share details have been changed.
Please indicate to your learned friend what is to be checked so that it is reflected. He'll indicate to you.
Eta check hoye, eta change hoye, eta to main.
Eta hoye jabe.
Director own
learned counsel for the alleged contemner submits that the order of this court has substantially been complied with. Full stop. However, comma, the alleged contemner was of the impression that the necessary corrections in the master data had also been effected. Full stop. Upon being detected not to have been done, comma, the necessary tickets were raised by the alleged contemner only recently. Full stop. It is expected that the necessary alterations in the master data shall also get effected within a week from date. Full stop. Learned counsel for the petitioner disputes that the necessary corrections have been effected in the records. Full stop. Be that as it may, comma, in order to grant some more time to the alleged contemner, comma, in view of the tickets having been raised recently regarding alteration of the master data, comma, let the matter stand adjourned till
1st of March, Milord.
March 1,
Yes.
2024.
No, 1st March, I have some difficulty. but
March,
no.
I'll keep it on March 8. I'm telling you why. Because 1 week, I'll give them some.
Right.
March 8, 2024. Full stop. The parties are to apprise the court on the next date as to whether the order has been complied with in its entirety in the meantime. Full stop.
Oblige. Oblige, Milord.
Let us see if it happens.
Yes, yes.
No, it will
I am
happen.
only concerned with my
Because
work to be done. That's all.
it will happen because it has already marked as defective, only some typopography.
So, Larry, please just indicate to your learned friends. I mean, do it later.
No, I will,
not right now.
going outside, I will show.
So, yes,
I will
just
show that the share capital has been reduced.
Very. Thank you, sir.
Oblige.
I'll show you.
Item number 25.
Yes, you're for the petitioner.
Petitioner, Your Lordship.
What is the content?
But I am for the state, my lord.
Copy has been served on
No,
it?
my lord.
No, this is
There
appearing
was no
for,
direction, naturally. Yes.
Lordship, it's appearing for the first time, Your
What
Lordship.
is the nature of content?
Lordship, there was a specific direction for paying the arrears, Your Lordship. The same was being calculated, Your Lordship, and the state had appeared, Your Lordship, at page 185.
Yes.
Page 185, Your Lordship, this order. May I place the order?
I'll just see the ordering portion first. This is for prima facie satisfaction. Yes.
Page
Yes.
186, Your Lordship, the state had
So, Ms.
appeared.
Ghosh, give a copy to your learned friend since he's appearing.
Lordship.
Direct you to serve a copy. Come back next week with the
Friday.
instructions.
Lordship, there was instructions that with regard to the Lordship, there were twofold submissions made. The state 186, learned counsel appearing for the state contends that the state on principle has no difficulty in applying the enhanced rate to the present petitioner in terms of clause 26 of the contract. However, it is submitted that the area rates ought not to be directed to be paid. That was a submission. Lordship, the very next page, page 187, Lordship has directed, in so far as the area rates are concerned, the same shall also be paid at the enhanced rate as depicted in the chart annexed at such and such for the month of December 2019 till June 2023. Such area payments shall be made by the respondent authorities as expeditiously as possible, positively within 2 months from the
Nothing
date.
has been paid till now.
Nothing has been
No, my
paid
lord,
as
I
the area.
just-
Lordship, let me.
Yes.
Lordship, nothing has been paid as the areas because there was a specific direction. And with regard to the rates from that day, Your Lordship, since they have already accepted that, Your Lordship, they have issued a notification immediately after that. That is page 210. That has nothing to do with the Lordship's direction was with regard to arrears. Page 210, Your Lordship, may kindly see it's a order, it's a government order of 30th of June 2023.
But that has to have prospective effect.
Prospective effect, but
Obvious.
that has nothing to do with
What
the
do you
area
say?
My lord,
payment.
may I submit? My lord, I just talked with my officer that they have submit that the payment that my lord's direction to disburse the amounts payable to the petitioner in terms of work done by the petitioner, my lord, they have already disbursed. They have already disbursed, my lord, in the second part, my lord.
Arrears?
Arrears pension, my lord, they have yet
Pension?
to filed. Sorry, my lord.
Not
Tender
pension, it will be
apology.
tension. Tension on the part of your officers, not pension.
No, my lord. The enhanced rate, my lord, so far they have.
Regarding the arrears, what is the
Yes,
stand?
my lord, they have filed prefer an appeal, my lord, and the appeal is yet to be filed. And first time the matter.
Before the appeal, the rule will be issued then.
Pardon my.
It's a competition now. Whether you can file the appeal first or I can issue the rule first. So I win because the matter is before.
No, my lord, kindly give me some 1 week time.
To file an appeal?
No, I will take the further instruction and my lord, the copy, my lord. The copy is not served, my lord.
Rates. Lordship's direction was with dispute with regard to the rates. So they
No,
have
we don't know what anything can happen in appeal.
Lordship, they have not filed any appeal. There is no appeal on record.
Yet to file, my lord.
There is no appeal as
Give
on
copies.
date.
You have to give copies first. It's
Lordship.
appearing for the first time. The petitioner has made out a prima facie case of violation of the order of this court. So accordingly, copies of the contempt application be served on the alleged contemners, indicating that the matter shall be listed on March 8, 2024, when the petitioner shall file an affidavit of service to that effect.
Lordship, a shorter date in that event, your Lordship.
I have to give you 2 weeks to serve. He's appearing
Lordship,
only for
I can serve it, Lordship, by Monday. I can serve it in 1 day. Lordship, he is already having the instruction. Lordship, Lordship, may very kindly.
Will there be proper service for all the alleged contemners?
Lordship, there's only one contemner.
No, my lord, there are the other
Three
party,
contemners are there.
Lordship, he's representing the state. The state is the only contemner.
State, my lord, that doesn't
he is
mean the all.
No, not necessarily. They will. I can keep it on first. If
Lordship, may very
No, my
kindly
lord,
keeps
kindly
it
take
on
it up
first.
on
He
the-
already has the instruction.
তাহলে
He
March
already has the
very well.
instruction.
March 8 না করে March 1st করে দাও. March 1.
Lordship,
Next
grateful to you,
Very
Lordship.
well. Yes.
হ্যাঁ।
Item was 27.
Yes, please.
Yes.
You are for the petitioner?
I am for the petition.
Appearing for the first time?
First time.
What is the nature of contempt?
Nature of contempt that he is not giving me electric connection by installing a transformer.
By installing transformer?
Transformer.
Yes, what do you say? Why?
Lordship, this is the first time I will take instruction.
Very well.
Whether why they have not.
So I'll direct him to serve copy on you directly?
This is the first time, my lord.
Yes, you will serve on her.
ठीक. Okay, my lord. I shall serve by today.
A prima facie case of contempt has been made out. Full stop. Learned counsel having instruction to appear for the alleged contemners seeks a copy of the contempt application. Push up. The learned advocate on record for the learned advocate for the petitioner. You have served.
Today, by today, I shall serve.
Only
The
he
learned
wants to phone
learned advocate for the learned advocate for the petitioner shall serve a copy of the contempt on the said learned advocate having instruction to appear for the alleged contemner during the course of the day. Push up. Let the matter be listed on March 1, 2024 under the same heading. Next Friday.
Yes, ma'am.
I'm grateful. Lordship.
Item number 28.
My lord, I appear for the petitioner, my lord.
Yes.
My lord, this is, my lord, a contempt application appearing for the first time. Lordship's order is at page 16. Initially, Lordship felt there is a arguable prima facie case, but directions were issued for affidavit. Thereafter, my lord, since they were, my lord, proceeding.
29.
28, my lord.
28, I'm sorry.
Yes.
I'm sorry, yes.
Yes, my lord, initially Lordship had issued directions for affidavit.
Yes.
But Lordship observed that there is a prima facie strong arguable case made out. My lord, then they were, my lord, violating. My lord, they were actually, my lord, again, my lord, giving the allocation to, my lord, those ATF, my lord.
This is a violation of an interim order.
An order passed by your Lordship at the interim stage in a CAN application. Kindly comes to page 19. It will, my lord, come back to your Lordship's mind, my lord. Page 19. It was, my lord, challenging a tender process, my lord, allocating of the tender work, my lord, to two, my lord, different kinds of, my lord, operators. And Lordship's observation, my lord, at page 20, after hearing the, my lord, counsel for the respondents, kindly comes to, my lord, page 20, paragraph 3.
Yes.
Counsel for respondents opposes such prayer and places reliance on the order whereby writ petition was entertained, in which clause 4E of the tender terms and conditions was primarily interpreted by this court in favor of the respondents. It is argued that as long back as in April last year, necessary inspection for allocating additional work to the ATF tank trucks were already undertaken, and only work orders remain to be issued in favor of ATF tank trucks. Then after, my lord, considering everything, Lordship at page 21, paragraph 8, passed this interim order. Respondent shall remain restrained from allocating any further tank trucks and or from issuing any work orders on any such allocation if already made in favor of ATF tank trucks for work contemplated in the present tender. So this would mean, my lord, My lord, although they had taken steps for allocation, if the work order was not issued, even the work order could not be issued, my lord, in view of lordship's order. Now, my lord, kindly comes to my lord, page 22, my lord. Lordship's order date is, my lord, 16th of February. My lord, the loading, my lord, if you, this is document is bit illegible, my lord, I'll just assist your lordship. My lord, the table, my lord, where it starts above the expression consignee, lordship will find a date, 17th February, 24. My lord, it should be
Yes,
like
yes.
here, my lord.
Yes.
Yes. So this is, my lord, where, my lord, after the order, this loading continues, my lord, in the ATF tank trucks. My lord, next document, there is, it is prior date. I will not bother your lordship with. Then I issue.
17.
No, for it.
17.
Oh, 23 is also, my lord, 17th February. 22 and 23 at two different times, my lord, trucks are being loaded, ATF trucks are being loaded. I issue a contempt notice, my lord, at page 24. And the last document I want to show is, my lord, at page. It should be, my lord, 28. Lordship will see the date again, my lord, at the, my lord, it's in landscape format, right hand side, my lord, 20th of February.
Yes.
Again, my lord, this, they were actually, my lord, contractors were engaged for the loading of ATF trucks. Now, they have issued a reply to the contempt notice, my lord. Original document. I'm handing up the original, my lord. My lord, they have annexed, my lord, a work order. Dated, lordship will kindly come to the, my lord, last annexure, my lord, the second last page. 9th January 2024 is a, my lord, document, is the document, work order.
Yes.
And, my lord, their contention with regard to this, lordship will find, in, if your lordship, my lord, comes back to the letter, the reply. Third, Roman 3, my lord. It is denied our clients have taken law in hand as alleged during pendency of the writ petition.
This is which page?
My lord, first page of the letter, my lord.
Yes.
First page, Roman III.
Yes.
It is denied that our clients have taken law in their hands as alleged during pendency of the writ petition. Our clients took a decision to give allocation to 5 number of TTs under ATF transportation contract of Howrah terminal to so-and-so ex-Howrah terminal. Pursuant to such allocation, 5 number of TTs, our clients issued work order to the said 5 number of TTs on 9 January. Now, this submission was not made first when, my lord, lordship was hearing the can. Second, my lord, when lordship had, my lord, recorded the submission at paragraph 3, the one which I drew my lord's attention to, it meant even if there was a prior allocation, the work order would not be issued.
They had issued the work order also prior to this order.
My lord, it's kindly comes back to your lordship's
cannot
order.
make any further assignment.
Yes.
Cannot, even if there is a previous assignment, they cannot issue work orders in terms of.
Yes. So they say,
work
my lord,
order was issued in January before the March order.
my lord, kindly comes back to page 21, my lord, once paragraph 3.
Yes.
Only, my lord, this submission which lordship has recorded made by the respondent.
Yes.
It is argued that as long back as in April last year, which would be, my lord, 2023, the necessary inspection for allocating additional work to ATF tank trucks were already undertaken and only work orders remain to be issued in favor of ATF tank trucks. Not, my lord, this work order is not the work order which is being referred to, my lord, in the reply.
Even then. The ordering portion has to be seen for a contempt application. They are restrained from allocating any further tank trucks and or issuing any work orders on such allocation.
My lord, their statement is, as on the date when lordship was passing the order, no work order was issued. If 9th January was the work order, they would have, my lord, possibly pointed out to your lordship that, look here, there was a previous allocation pursuant to which I have in fact issued a 9 January work order. It's, my lord, antedated. My lord, there's
contempt is on a much higher. They had issued their work order.
I was only relying upon their submission last line. Only work order remains to be issued. On that day, if he says work order remains to be issued, there could not have been a 9 January work order. This is, my lord, to circumvent your lordship's order that in this manner this is being done. That is the reason I come.
File 340, I'll decide that the wrong impression given misrepresentation.
I don't want to waste lordship's
our
time.
understanding and the reply also para. Kindly see para 5 once. Para 5 once in the reply to the contempt note. This is our explanation, Mala, to the.
Okay.
No, Mr. Rathod.
And, my lord, last paragraph, page 21. The third line, and or from issuing any work order on any such allocation if already made. Any such allocation would mean the prior allocations. And on that day, if Lordship, my lord, there was no work order, at least pointed out to your Lordship, no work order could have been there.
Should have pointed out.
No, the
They should have pointed.
Very well.
the discussion
I
was
understand
that-
why Lordship is
I
not.
still remember that in the affidavit in opposition which we filed in
See
August.
the innocent face of Mr. Nag.
Then restrain from further.
I leave it to you, Lord.
Then restrain from further load.
My lord, at least, my lord, restrain them, my lord, from
Restrain
further.
your learned junior from making a single, giving a single
Very
more
well.
instruction.
I leave it there, my lord. My lord, may I take back the original? I can
Yes,
give a
yes.
copy, my
No,
lord.
no, yes. File the copy. Yes.
It's slightly marked, my lord, the copy. I have a fresh copy also, my lord.
You may not give the copy also. I may not. I need not take this on record.
Very
I'll just refer it. The petitioner alleges that in willful violation of the order dated February 16, 2024, passed in WPA 16220 of 2023 and the connected applications, comma, the alleged contemners have allocated ATF tank trucks, have allocated further tank trucks on subsequent dates. Push up. Next para. It is contended by learned counsel for the alleged contemner that regarding the transportation taking place subsequent to the order in question, comma, work order had already been issued in the month of January, that is prior to the order. Full stop. It is pointed out that the parent order restrained the respondent authorities from allocating any further tank trucks and stroke or from issuing any work orders on any such allocation if already made in favor of ATF tank trucks for work contemplated in the tender in question. Push up next para. Upon a perusal of the materials on record and hearing learned counsel, comma, I am satisfied that there has been no violation of the order dated February 16, 2023, 2024. Pushed up. Next para. The purport of the said order was that no further new allocation would be made and or work order would be issued, comma, if not already done prior to the said order. Full stop. In the present case, comma, the work orders in question had already been issued prior to the order of this court, and as such, comma, there is no violation in terms of the order of this court. Full stop. Thus, comma, there is no scope of entertaining the contempt application. Accordingly, CPN 358 of 2024 is dismissed in the light of the above observations.
Grateful. I am taking back the reply now.
I've not recorded anything on it. Yes.
Item number 29.
But this is not my application on behalf of the my lord respondents, my lords.
You are for the
Lordship-
writ petitioner.
Your Lordship,
My lord,
this matter is pertaining to 2027, wherein I have paid 4 crores with the registrar.
2027.
27.
okay, two.
I have paid 4 crores before the Registrar General. If your Lordship,
2027 means?
uh,
My lord, let me, my lord.
No, you are not having any question in that regard. You don't dispute that it's regarding 2027.
My lord, kindly, my lord, just
2017.
2017, my lord,
Don't
they
have
have
determination.
filed
My
an
mistake, my
Right.
mistake.
in the years.
Defense, I don't have determination.
Well-
What, my lord? I have. That is why she submitted.
Your Lordship, there was a direction.
Yes, learned counsel for the respondent in the application and the petitioner in the writ petition points out that this court has determination to take up matters from 2021 onwards, whereas the present application relates to a writ petition of 2017. Push up. Hence, comma, due to lack of determination, comma, the matter is released from my list with liberty to the parties to mention for being enlisted before the appropriate bench having determination. I'm sorry.
Much
Yes. 2021 থেকে আমার determination যদি আগের সালের হয় না একটু দেখে নিও যখন মুখে বলে দিও।
Item number 30.
That is same.
I am for the respondent bank, my lord.
Same. Don't have determination.
Lordship,
20 don't have determination.
Lordship, in this matter, your
What is the
Lordship-
application for?
Lordship, this
Let
application,
me
Lordship
speak,
has passed an order.
regarding maintainability, I have to submit something, my lord. Thereafter my learned friend may start.
Lordship, in this matter, your Lordship had
Regarding
passed an
mental
order, your
quantity.
Lordship. On the day when the order was passed, the petitioner had passed away a day before. I have only preferred an application for substituting the name of his daughter and wife. That is the only application all about.
Now, the dispute has been disposed of, number one. Number two is the no death certificate are still annexed. It is the UD case I have found in page number 11. UD case, page number 11, kindly see. Is the
Death certificate is?
no death certificate is annexed today, along with the application. Second thing, they want to, after disposal of the writ petition, whether they can file any application.
Yes, then it was passed in the name of a dead person.
And
It's
a
a
person.
nullity.
Lordship, it was
Nullity.
passed in the name of a
Nullity.
dead
So,
person.
and another
On
thing is
that
that-
day, he had passed.
I'll recall that order because it was a nullity.
And
And
another-
I'll keep it. Before
Another
that.
thing, my lord, they are
You
trying
have a
to.
better chance before another bench because generally the tendency of us is to
Yes.
retain the order of another judge.
Lordship, in since there is a
Can 2 of
2020
2024 is for substitution of the names of the deceased writ petitioner, whosoever transpires that the writ petitioner had met his demise immediately prior to the disposal of the writ petition. Hence, comma, as on the relevant date when the writ petition was disposed of, comma, the writ petitioner was not in the realm of the living. Full stop. Thus, the order dated January 9, 2024, passed in WPA 5924 of 2020, is a nullity and is hereby recalled on such ground. Full stop. Next para. The writ petition, comma, along with can 2 of 2024 shall now be listed before the appropriate bench having determination. Full stop. Since this court does not have determination, since this court has determination to take up matters at the present juncture only pertaining to the year 2021 or after, comma, liberty is given to the parties to mention the matter for enlistment before the appropriate bench having determination.
Grateful, Your Lordship.
Number 31.
My lord, only my lord, my lord, single day accommodation, my lord.
But I am for the
Single day means it's an application, then it goes to the
Friday,
direct-
Friday.
You are for the petitioner.
Yes.
I'm the applicant, my lord, of the private respondent in the writ petition. Application took out by me.
What is the application for?
My lord, in fact, my lord, frankly, my lord, I submit my grievance for expeditious disposal of the writ petition. 69 years, my lord, the private respondent, the order of
Right now.
maintenance,
Not possible right now.
my lord,
Not possible.
there is a direction of earlier coordinate bench. Your lordship, please have a look. They are not paying the electricity bill.
My lord, this is totally wrong. I can produce all the bills I am paying. Today I have no briefs, but next day
I'll direct it to appear the writ petition. I'll dispose of the CAN application expeditious hearing, and I'll direct the matter to appear in the second week. I'll give a date under the upgraded heading.
Grateful.
Learned counsel for the applicant submits that the application is primarily for an expeditious disposal of the writ petition. Full stop. Upon hearing learned counsel for the parties, CAN 1 of 2023 is thus disposed of by directing WPA 9437 of 2022 to be listed under the heading upgraded matters on March 12, 2024.
Grateful to
Grateful.
Item number 32.
For the respondents. If a copy of the reply need to be filed, my lord, need to take some instructions on this particular reply, my lord. Well, if my lord kindly takes it up a week hence, my lord.
My lord, if I may file the reply today.
Yes. Opposition you have filed already.
My lord, oppositions have been filed long back.
Affidavit in reply filed to be kept on record. Full stop on the prayer of learned counsel for the respondent number.
My lord, I'm the respondent Damodar Valley Corporation, respondent number 2.
For the respondent stroke Damodar Valley Corporation, the matter is adjourned till March 1, 2024. File that. ওটা নিয়ে নাও প্রীতম, কি করছো?
My lord, led by Mr. Probal Mukherjee, my lord, in this matter.
He's
But
in
I'm-
court.
My lord, he is virtually appearing, my lord.
But I'm led by Mr. Tanmay Chakraborty.
Item number 33.
Yes. Yes, Mr. Bhattacharya, what is the matter?
I have come up, my lord, by way of a review application.
Right. Yes. What is the ground of review, Mr. Bhattacharya?
My lord, the entire case was not taken into consideration. My lord,
The order about.
my lord, the
Mr. Chatterjee,
petitioners,
is with you or your other side?
I don't have the gumption. I don't know. But that's why I'm a little away.
perhaps, my lord, he's opposing.
Yes.
How can I, my lord? I asked this question to myself.
He's assisting you to reach the right conclusion that you are wrong.
I cannot assist also.
You are assisting him to reach the right conclusion that he is wrong. Yes, Mr. Bhattacharya, what is your case?
Now, my lord, the petitioners before your lordship, my lord, they are the writ petitioners as well as the review applicants. They are all, my lord, villa owners of the, my lord, complex, my lord, in somewhere in Rajarat. They moved your lordship's court, my lord, assailing inaction on the part of the competent authority, my lord, constituted under the Apartment Ownership Act, my lord, to redress their grievances. Now, my lord, when the writ petition was presented in this honorable court, my lord, the election, which the so-called election, my lord, which was held, that election was not formally conducted. Formally conducted means, my lord, when the writ petition was presented, the election was in the offing, the election was, my lord, about to be held. Ultimately, the election held. And, my lord, your lordship took into consideration, my lord, while dismissing my writ petition, my lord, took into consideration the fact of the election having been held, and, my lord, in an ancillary issue, my lord, regarding a suit which was presented, my lord, in the appropriate civil court, my lord, on a different context, not on this issue. Now, my lord, what was not shown to your lordship is, my lord, what was not told to your lordship is, my lord, it is my mistake, I say, my lord, that there are in this organization, in this complex, one company by the name of respondent number 7, my lord, the respondent number 7 is a section 8 company. Today, section 8.
Sir Bhattacharya, this is neither a discovery of new material nor an error.
No, it is an error apparent. Why? Because your lordship was, you know, just, you know, I may be, you know, incorrect, you know, 7 is a company. Now, 7, you know, the promoter, whoever was there since 2012, this company is registered under the, you know, previous 1956 Act. It's a section 25 company for charitable or whatever purposes. Now it is section 8 of the Companies Act, the new act. Now, my lord, this section 7 company was running the show for all this time. And these persons, whoever is there, 8, 9, 10, 11, 12, 13 and 14, you know, these persons, you know, they are apparently the directors of that so-called section 25 company. Now, my lord, in a complex where the Apartment Ownership Act is to, my lord, prevail, and, my lord, the Apartment Owners Association is to prevail, my lord, this company was running the show. The promoter transferred the entire, my lord, money in favor of this company, and the company, rightly, wrongly, illegally was running the show. Ultimately, my lord, some of us, we took steps to get the Apartment Owners Association registered formally. Now, my lord, that registration took place in the year 2020. Thereafter, my lord, one attempt was made by some of the persons, my lord, alleging that, my lord, inaction on the part of the competent authorities. Which persons? My lord, these persons. My lord, an order passed by a coordinate, this was not shown. An order passed by a coordinate bench of your lordship's court, my lord, relegated the entire matter to the competent authority. The competent authority again held in my favor. Ultimately, when nothing was there, they came to your lordship's court, my lord. At page 384, they came by way of an independent writ petition saying that this entire registration process, the registration that was obtained from the Apartment Owners Association or the, my lord, the competent authority or, my lord, the housing department, that registration was fraudulently obtained. And, my lord, your lordship's court at page 384, the initial order is at page 384, the final order is at page 293. My lord, 384, one question cropped up: what is the jurisdiction of these persons, my lord, to come to your lordship's court? My lord, kindly seize the order. These things were not shown to your lordship. Ultimately,
how did it make a difference? What
lord,
do you mean?
why? Because, my lord, ultimately,
what was not placed before?
384 was not shown.
Which is an order.
384 is an order made at the instance, in a writ petition carried by some of the private respondents
What
here.
was the direction there?
That kindly see.
Now tell me, what was
The direction was they were to just justify or satisfy their locus to present the writ petition one. Ultimately, the writ petition came to be disposed of.
Yes.
And ultimately,
material.
it is because an election today. I was that section the 2020 registration. Ultimately an election took place. 24 board managers were elected. We were the 24 board managers. Some of us. Now, these persons, the private respondents, they were not paying their regular charges to us. They were not recognizing us. They came to your lordship's court alleging that this constitution has been illegal. All these things, ultimately, when everything failed, now they have conducted an election by whom, in violation of the 2022, regulation 11, where it contemplates, that a person has to be a regular voter. Any apartment who fails to pay in any installment of his contribution, these persons never recognized respondent number 27 in the writ petition. They never recognized respondent number 27. Respondent number 27 is the formal association of the apartment owners registered under the Apartment Ownership Act. That association initially was constituted, and there were, writ petitions carried to your lordship's court. Ultimately, all attempts at their behest, failed, and the competent authority ruled in our favor. Those things.
Mr. Bhattacharya, the premise of this court, as reflected in my order, is that it transpires from the nature of the allegations that those are beyond the purview of 16B. Meat of the allegations is against some of the villa owners, which villas comprise of the housing complex. Such unlawful acts, if any, they do not come under section 16B1, for which you are relegated to the civil court, because if you want to...
Today what is happening, why what prompted me to disturb your lordship by way of this review is because your lordship, while passing the order, was not invited, your lordship's attention was not invited to the fact that the respondent number 7, a company cannot run in a housing complex. 1. 2 is, this respondent number 7 company, they are direct
on the jurisdiction of section 16B, the scope of operation of 16B.
Yes.
My order was clear on that.
Our
If a
grievance
company
today
does
is,
that,
that our association was not being recognized by those company people. Today, there is a separate entrance for us. They have totally, swindled with the entire money, whatever was there, the principal money, there is no common entrance. And what is happening is, we have a separate, security person who opens our gates. These things have to be told to your lordship, what is troubling us.
But these were available at that point of time. You appeared in the matter.
Undoubtedly. These things, the writ petition was dismissed on the first instance. At the first instance, yes, on the first day.
On the first day, not at the first instance.
On the first day.
At the first blush.
Yes.
This was decided. The reasons were given. This is an order on merits of the meat of the matter.
Kindly seize,
This will require a rehearing. We cannot reopen an order for rehearing under review. You are bringing in certain other allegations.
Not allegations, which were on record, but it was not ignored. It was not shown. I do not say that it was ignored. I say that it was not shown.
Suppose, Mr. Bhattacharya, those were overlooked. How would it make a difference?
It was
it
what
would bring it within 16B.
Today, yes. Because with respect, initially, prior to the promulgation of the 2022 bylaws, association like this contemplated 24 board managers. Now it is 48 board managers. These 24 board managers, whoever taken the, whoever was running the show, was completely ignored by these persons who have now been elected. Dehors, Rule 11, Regulation 11 of the 2022 bylaws. That is one thing.
That will be a hearing, because it was recorded that the plinth of the arguments of the petitioners is apparently that due to the unlawful action of several of the villa owners, the functioning of the association could not take place properly. Now, this was the
Well,
first
wha-
sentence.
yes, because
Even if you say the company was running the show, then also the
well, the
plinth of the
company,
allegations,
the
plinth of the
directors of the
allegation-
company,
plinth of the allegations remain the same.
well, the directors of the company, whoever was there,
Yes.
they came to your lordship's court questioning the registration by the housing department. Their challenge failed.
This will be amenable to appeal, then prefer an appeal.
Milord, I want to persuade your lordship, Milord, to Milord, come to our rescue to a very limited extent. Milord, my grievance today is, Milord, that this parallel administration cannot go on. One recognizes the other recognizes. Milord, they are putting, Milord, what has happened? They have closed bank accounts of the 27.
Mr. Bhattacharya, then you are always at liberty to file a proper objection before the competent authority,
Milord,
fresh application. If it comes
we
within
have,
6
Milord,
MB, then they will entertain.
those needed to be, Milord, heard by the competent authority. That was our principal prayer.
Whatever allegations were there,
Today,
at that point of time, it was not required to be heard. That was held at least.
that is, yes.
Now, if you have further continuing grievances which fall within
Continuing
16,
grievances is another thing. Continuing grievances does not give me right of review.
this is a
Milord,
fresh.
on the date when the writ petition was decided in the month of October, Milord, according to me, Milord, page 384, 293 and 295 was not shown. And apart from that, a previous order
Let me see page 384,
please,
384 of the review application.
of this application.
If a review application is more than 400 pages, Mr. Bhattacharya, that itself should be a ground for saying that
Milord,
just
the
because
writ petition was Milord, writ
longish.
petition ran into, Milord, 200 and something pages. Therefore, it is, Milord, so thick. It is 337 pages.
So I've heard of gold being weighed on one side and the person on the other. But writ petition and the counsel being weighed on two sides of the scale, I've first heard.
Well, I have no weight. Physical weight, yes. Maybe otherwise
Physical
I
weight,
don't have.
yes. I'm speaking of
Physical weight, yes.
You on one side and the writ petition on other. I mean,
Kindly see.
petition is gold, obviously. 384 what? How does it make a
Milord,
difference?
this is at the instance of the company.
Yes.
Milord, first is, Milord, kindly do not, Milord, this is not by the respondent number
No.
27. It is by the respondent number 7 to the present proceedings. This writ
Which
petition,
was the company.
which is the company.
Yes.
It is, even today, it's a company.
How does it make a difference?
Milord, it says,
Yes.
learned counsel appearing for the petitioners has started submission on the legal position. It is the admitted position that the petitioners were registered as an association under the provisions of the Companies Act, whereas there is a rival association which has not been made a party to the writ petition, which has been registered under the provisions of the West Bengal Apartment Ownership Act 1972. The petitioners say that the rival association of which some of the members have been made party respondents does not enjoy the valid registration. That is their case. The reason for this is a certificate which has allegedly been obtained by fraud. However, this court is of the view that the petitioner must satisfy that the petitioners are registered under the 1972 Act in the capacity of an association. Now, Milord, this writ petition ultimately was disposed of at page 293, kindly comes. 290. 290. Of course, Milord, the question which was left open on the first day, that is 10th of April 2019. On the 17th of April, Milord, this Honorable Court felt that the entire issue should go to the competent authority for a decision, including all the issues. Milord, kindly seize the order. This is the ultimate. It is an admitted fact. I'm reading, Milord, page 290, second paragraph. It is an admitted fact that the petitioners applied before the competent authority under the 1972 Act on 13th September 21, and the competent authority has already heard the parties 4 times, the last of which was on 20th of May 2022. The private respondents are also before the although learned counsel appearing for the competent authority states raises a point of authority not being competent to go into the issue in question. This court is of the view the concerned authority shall complete the hearing which started, etc. within a period of 3 weeks from date, as a petitioners are already before the no additional directions are required to be passed, the competent shall pass a reasoned order. And Milord, kindly sees the reasoned order now, Milord, page 293. This is apropos, Milord, a decision of this Honorable Court, Milord, filed in the petition. Milord, in compliance with the order, Milord, page 293, in compliance with of the order dated such and such, passed in such and such, the hearings which started on complaints dated 1/2/21 and 13/9/21 from Mr. Dilip Sheth. Milord, I think my learned friends are representing Mr. Dilip Sheth. And, Milord, the entire, Milord, coterie of persons was completed. The parties submitted written notes of argument. The relevant points raised by the parties in their respective arguments are produced below. This authority received complaints dated such and such, praying for cancellation of the registration of Ideal Villas Apartment Owners Association bearing registration number such and such, dated 17th February 2020. Director Ideal Villa, from Mr. Dilip Sheth, Director Ideal Villas Owners Association. Now, Director Ideal Villas Owners Association is the company. The parties were first heard on this. The main issue before this authority is whether the association was formed in accordance with law or not. Submission of copy of completion certificate along with the Form A is a statutory requirement for formation of association under the West Bengal Apartment Ownership Act. The complainants alleged the copy of the CC submitted before this authority along with Form A is not a CC issued by the concerned Gram Panchayat. After narrating the entire factual matrix, please ultimately see, the competent authority, it holds page 294.
Yes.
The competent authority has no authority or power to review its own order, and issuance of certificate of registration of any association or recall and or withdraw or cancel of the registration as granted on any date. Therefore, the petitioners' complainants demand prior to the CA to review a issuance of the registration of the Ideal Villa such and such, registration number such and such under the Act of 1972 is beyond the jurisdiction of the authority vested on the CA under this Act. Same admittance is reflected in the court order dated this first sentence of the third paragraph, where the learned counsel appearing for the CA admitted this. And it relies on Supreme Court judgment in view. At page 295, it is hereby ordered the Ideal Villas Apartment is bearing registration number. This is valid. So, therefore, the association was declared to be valid by this order, which was made on the 18th of May 2023. Now, prior to this 18th of May 2023, there was an election after the registration, which election was never recognized by these persons. Which election was never recognized by these persons? By these persons, the complainants here, the private respondents in the writ petition.
It was held to be valid.
The registration was said to be valid. So the functioning was also valid. Now these persons never paid their monthly charges that common expenses that is to be paid, because they never recognized respondent number 27, the association, and therefore then whatever was supposed to be paid by these persons, it remained unpaid. Ultimately, when this challenge failed, they have now, the term was getting over. 3 years is the term for the association, 20 to 2023. Now, they suddenly jumped to hold an election, and they are clearly debarred by Rule 11.
Mr. Bhattacharya, this is a rehearing, which is not permitted in legal. What is the error apparent on the face of the record?
These documents were perhaps not considered, but that is my case.
Go up in appeal. I'll give you that. I need not give a liberty. No.
And functioning of the company should not be there. There cannot be any company when the association is there. And they have written to the bank to stop the operation of respondent number 27's accounts.
Company is acting in what capacity? Is the developer?
Company is acting, the developer is above. Respondent number 12. With the blessings of the developer, the entire offer, whatever is generated, was generated in 2012.
What is the capacity of this company?
It's a section 25 or a section 8 company now. It is running the show.
No, vis-a-vis this association, what is the, it's
a parallel body which is running.
No, it's an owner of one of the flats, the company.
Yes, it's all, the directors are all persons who are villa owners. Kindly see.
Directors maybe. Is the company also owning a villa? One of the
No, not owning a villa. It's running the entire association. In the garb of this company, what is being done, a parallel administration is going on. A parallel administration is going on. We are prompted to engage our own security men. They are writing to us. Latest notice. Kindly see, after when the matter was last taken up last Friday, the matter could not be heard. Then thereafter,
where is the where is your complaint to the competent authority, which was, I held that the competent authority does not have jurisdiction to decide what? Where is that complaint of you?
Kindly gives me a moment.
Mr. Bhattacharya, in any event, in substance, what you are arguing is on the basis of the materials which were there in the writ petition, the decision should have been otherwise. This requires a hearing. This is a reopening of the entire hearing, not an error apparent on the face of the record.
Milord, what prompted me to again, Milord, I am saying.
Maybe an error of law
Milord,
or fact,
there is no question of, Milord,
but it is
Milord,
not apparent on the face.
these things, Milord, was not considered by your lordship, and therefore, Milord, according to me, some ground of review, Milord.
No, I'll hold that. The order will be very short.
Milord, kindly.
No, Mr. Bhattacharya, I'm actually being frank to you. This requires a rehearing. You have already established that.
So, Milord, if it requires a rehearing, Milord, your lordship will, Milord, call for a.
Not error apparent on the face of the record.
Milord,
That is the
the
precise
question of maintainability
precise
of
rider
the
in
review may be
review.
kept open. Let them file affidavits disputing whatever I am saying.
In a review.
Let them. Milord, the review, Milord, keeping the question, Milord, open, Milord, they cannot run the show in this fashion. They have been writing to the bankers, they have been running, Milord, everything, Milord, and they have, Milord, totally today, after the, Milord, this is the latest position.
Yes.
On 18th of February,
No, Mr. Bhattacharya.
removal of your generators.
Learned counsel for the review applicant submits that the respondent number 7 company is running the show in the affairs of the housing complex, comma, which is the subject matter of the dispute. Full stop. Next para. It is contended that some of the documents annexed to the writ petition were not considered by this court while passing the order under review
That is,
dated October 11, 2023. Push up next para. Learned counsel seeks to impress upon this court that if such documents were considered, comma, the outcome of the writ petition might have been otherwise. Push up next para. It transpires that the review application annexes several documents. Push up next para.
Not the review, it is the part of the writ petition.
Comma, which were part of the writ petition. Push up next para. However, comma, the argument now sought to be advanced by the review applicant does not come within the purview of error apparent on the face of the record. Full stop. Next para. The sine qua non of a review is that there must be an error apparent on the face of the record or discovery of new material or some other ground akin to those. Full stop. Next para. The question of discovery of new material does not come up here since the materials were already annexed to the writ petition. Full stop. Next para. Insofar as the alleged error in the order is concerned, comma, the same cannot be apparent on the face of the record, comma, since a detailed rehearing of the writ petition itself is required, comma, upon a reappraisal of several annexures to the same, comma, for coming to a conclusion on the contentions of the review application. Full stop. Next para. The said exercise, comma, as is well settled, comma, is entirely beyond the scope of a review. Full stop. Accordingly, RVW 282 of 2023 and the connected CAN 1 of 2023 are dismissed without any orders to cost.
It does not foreclose my right.
Does it? Does it?
Perhaps no, but Milord, even an observation would have not sufficed.
At this stage, no. If you're starting your practice, yes. If the application rejected, it affects the
No,
appeal.
of course not.
The other way around, definitely.
But even the other way around has been put to rest, Milord, by the Supreme.
Yes.
2020, volume 9, page 90.
Justice Narsim was
Not Justice Narsim.
This is why, Milord, he is pro.
You were there in that matter, you must have argued.
No. I have, Milord,
judgment to
I
come.
had the occasion to assist,
But
Milord,
that
Mr.
judgment to come, Mr. Bhattacharya,
Milord,
a very innovative argument must have
do
been
not
required.
take it any other way. Milord, I had the occasion to assist, Milord, the previous learned Advocate General, Mr. Mukherjee, Milord, where this entire branch of law was gone into in a review, and ultimately the division bench held that, Milord, it's a fit case for review. Anyways,
I should not comment.
Milord,
Well, close. Yes.
My lord, 34, next item.
No, fixed, and a matter is fixed, yes.
The other matter, we continue.
I don't think I'll take much time today.
No, no.
It's almost
start.
done. Almost.
Yes.
Now, my lord, yesterday, my lord, I was trying to, my lord, bring down
Now this.
to the judgment of Justice Bhattacharya, my lord, saying that his lordship noticed the Ashok Kumar's matter, but then thereafter, my lord, did not adhere to the third paragraph. My lord, my endeavor before your lordship was always that to show your lordship that there has been an infraction or breach of law, and the High Court was not denuded even in the, my lord, where Article 329 applies to my lord, interfere, my lord, for the ends of justice. I also tried to show your lordship, my lord, that there are two things. One is High Court can interfere, and the second is High Court can interfere, but in the present situation, even on merits, the High Court should have interfered. One was on can or cannot, and the other side is, my lord, can but should have. Both, my lord, in my respectful submission, my lord, in whatever I have tried to show before your lordship is that the views of the Honorable the Chief Justice was more plausible than that of my lord Justice Bhattacharya. My lord, we ended yesterday, my lord, while I was citing the judgment of Taposh Pal,
Yes.
where, my lord, the Honorable the referee court, my lord, held something which was not there in, my lord, both in the differing judgment.
Yes.
Briefta কোথায়? One second's time.
Yes, yes.
One minute's time.
Yes, yes.
My lord, I was কোনো বই আনেনি?
Judgment এর পক্ষে কিছু representation একটু আছে যেটা থেকে দেখাবো রুলসটা এখানে 5-1 এর স্কোপিং সেগুলো আছে অসুবিধা
Well, I'm a little handicapped. For some reason, my entire bag of books have not arrived.
Oh. It's come to court. Like a
Has not come to court. I don't know why. এ থেকে বেরিয়ে যায় না। My lord, if your lordship now comes back to, my lord, the judgment of Justice Bhattacharya, my lord, it'll be profitable, my lord, to show your lordship why I say, my lord, that Justice Bhattacharya went.
How many judgments you are?
Lord, I would have cited about 4, and more importantly, my lord, was that the judgment cited by my learned senior friend, they had to be shown to your lordship.
No, I can hand over a copy
No,
of
but I'll come to that. My lord, your lordship takes up Justice Hiranmaya Bhattacharya's judgment. Kindly looks to, my lord, paragraph 31 first. I won't take your lordship to the entire because that will be a waste of time. It was placed before your lordship. Just those relevant places where I would show, my lord, that Justice Bhattacharya probably overlooked, my lord, what the real problem was. Mr. Chatterjee, learned advocate representing the writ petitioners, 31. Respondents seriously disputed the submissions of Mr. Dotto by referring to Rule 5 of the relevant rules governing the election of members to the council. Mr. Chatterjee contended that it was incumbent upon the returning officer and 2 members of the council to hear out the objections filed by the writ petitioner, and since there has been a failure on the part of such authorities to perform the duties vested upon them, the writ court was well within its powers to interfere in such cases. By drawing the attention of the court to the grounds for rejection of the nomination papers Mr. Chatterjee tries to impress upon this court that the order of rejection was improper. Now, the entire premise is that there was a rejection, but basically, if your lordship would see, there was really no rejection. They did not even take it up. They did not even accept the objection. Lord, your lordship comes back. Mr. Showers, your lordship is not interested. Kindly looks to 35. Though his lordship holds there was elaborate arguments, but basically there wasn't any. Then 36 is the points, and 37 is where the period has been noticed. This is important. Election notice was issued on 12/12/2022, notifying that a general election of member of the council under section 19A of the 1948 Act will be held. In the said notice, it was stated that filing of nomination shall start on 12/12/2022 and will continue till 16th of December 2022. The date for scrutiny was fixed on 19th of December 2022. It was stated that nominations can be withdrawn at any time before the scrutiny of the nominations, and 3 days, that is till 22/12/2022. Now, this is important because this here, my lord, this period of 3 days was, my lord, brought into question. Kindly looks at it once more. The date for scrutiny was fixed on 19th. It was stated that nominations can be withdrawn at any time before the scrutiny of the nomination, and 3 days thereafter till 22nd of December 2022. So, my lord, it was only after scrutiny that, my lord, the nominations could have been withdrawn. So that has got nothing to do, my lord, with why my objections with respect to rejections cannot be taken up, my lord, before the ballot papers were sent. That is, my lord, probably on the 9th, sometimes in January.
And the voting papers were to be dispatched on 9th of January.
9th of January.
And you filed the objection on 1st.
On the 1st. I say, my lord, I put up my objection on the first day, asking for reasons. Took a little bit of time thereafter, my lord, to show that the reasons were completely malafide. And there was nothing which said, my lord, that before that sending of ballot papers, my lord, that the things could not have been put at rest. So these 3 days has got nothing to do, my lord, with respect to consideration, my lord, of my objection. Because in my respectful submission, my lord, such a long gap was given because a committee had to be, my lord, formed. Committee of 3 persons had to be formed, my lord. They had to come, they had to assemble, and they had to hear. So all this had to be done. That is why, my lord, such a long gap was given. So and nothing prevented them, my lord, from looking into the objections, seeing it, my lord, objectively, and then, my lord, passing a decision within that period. And it's only after that that they could send it, my lord, to the voters. This was also lost sight of, my lord, by Justice Bhattacharya. Then kindly turns down 39 once. In order to decide the question that has cropped up in this instant appeal, it would be relevant to take note of some provisions laid down in 1948 Act and relevant rules for election framed thereunder. For the purpose of election, the requisite members from amongst the registered pharmacists of the state, election notice was issued under the provisions of Section 19A of the 1948 Act. Chapter 3 of the Act starts with Section 19. Section 24 falls under Chapter 3 and states that elections under that chapter should be conducted in the prescribed manner, marks it. Manner, and where any dispute arises regarding any such election, it shall be referred to the state government. Catchwords are any dispute regarding any such election. I am saying, my lord, we are not taking it higher to an election dispute. I have an inbuilt mechanism at the threshold. The statute gave me a right. Section 46 of the said Act empowers the state government to frame rules, and in exercise of such power, the rules for election was framed. Rule 23 states that if any question arises as to the validity of any election, we are not questioning the validity. The question shall be referred under Section 24 to the state government whose decision shall be final. Now, very important. From a conjoint reading of section 24 and rule 23, it is evident that the power to decide any dispute arising regarding such election has been vested upon the state government, who shall exercise the jurisdiction vested upon it by the statute which confers such jurisdiction. This is the error on the face of it. On the face of it. Because it completely undermines Milord Rule 5.1. And Milord, this is in a way, Milord, jumping into something with before Milord looking at the dispute with respect to Milord at the threshold. That's the nomination. Milord, if Rule 5.1 was not there, rather if Rule 5.1's second part was not there, Milord, this decision would have held good. Milord, I would have had nothing to say. But once Rule 5.1 comes in, Milord, I'll show your Lordship the consideration on 5.1. Milord, with a lot of respect to his Lordship, Milord, did not consider the second part at all. That mechanism. Did not consider. Milord, this is 41. Then 42 also. Section 24 uses the expression any dispute arises regarding any such election. Such expression has a very wide connotation. Marks it. The said expression necessarily implies that any dispute arising out of such election can be raised only before the authority vested, kindly marks, with such power under the statute and in the manner and the time as prescribed under the relevant rules. This court has to thus consider whether rejection of nomination can be said to be a dispute arising out of such election. The premise of adjudication is, Milord, haywire. Is wrong. Because it gives a go-by, Milord, to the first part that at the threshold I have a right of adjudication and a right to raise an objection. The right to contest the election flows from the said statute. Therefore, such right shall have to be exercised strictly in accordance with the provisions of such statute and shall be subject to the limitations imposed by it. I bow down. Milord, in a way, Milord, I want to rely upon this. I want to rely upon this. Rejection of nomination, no doubt, curtails the right of the nominee to contest the elections, but the questions remains as to the forum and the stage for redressal of such grievances. Again, very important. This is, Milord, I say, Milord, Justice Bhattacharya recognized the principles, but could not apply it because probably his Lordship, Milord, lost sight of 5.1 second part. The learned single judge was of the view that rejection of nomination of the writ petitioners caused serious injustice to them, and for such reason, the writ court interfered in the matter. The learned single judge also took great pains to look into the reasons for rejection of nomination to ascertain as to whether such rejection was proper or not. Furthermore, the learned single judge was of the view that the objection to the impugned rejection was within the parameters of Rule 5.1. Marks it. As according to the writ court, there is no time limit within which such objection is to be taken. On such findings, the objection against rejection of nominations were allowed. Mr. Chatterjee would contend that the concerned authorities failed to perform their duties vested upon them by not hearing out.
Were not allowed by Justice Moshe Bhattacharya.
But they were allowed.
Objections were allowed or they were directed to be heard?
Were allowed.
It
It was allowed. Milord, the nominations could have been rejected on the basis of, Milord, Rule 3. Milord, I'll show you, Lordship.
We'll go into that. That's a different.
I'll show you, Lordship.
Yes.
In terms of Rule 3, the reasons which they had given, that you did not give the address, you did not give the date of birth, they were not within that Rule 3. So, his Lordship and the Honorable the Chief Justice said that there is complete malafide in the actions of the opposite party, so the objections were allowed.
Yes.
Then 5.1, Milord, is given. Subrule 2 of Rule 5 entitles every nominee and one duly authorized representative or his proposer or seconder to be present at the time of scrutiny. The object behind insertion of such provision is to afford an opportunity to a nominee to raise an objection at the spot in case he is aggrieved by the decision of the returning officer. Though no time limit has been fixed for filing of objection under Rule 5.1, but the said rule uses the expression forthwith. It is well settled that if the meanings of words used in the relevant statutes or the rules framed thereunder cannot be gathered therefrom, the dictionaries may be used as an aid to resolve an ambiguity. The Honorable Supreme Court in the case of such and such.
These were not cited, you said.
No. This was, my lord, Justice Bhattacharya's own, my lord. Held that the ordinary dictionary meaning cannot be discarded simply because it is given in a dictionary, and do that would be to destroy the literal rule of interpretation. It was further observed therein that it is a basic rule to rely upon the ordinary dictionary meaning, which in the absence of some overriding or special reasons to justify a departure must prevail. Therefore, the dictionary meaning of the word forthwith can be relied upon in order to resolve an ambiguity as to the time limit within which the objection under Rule 5.1 is to
In
be
this
filed.
case, dictionary does not actually remove the ambiguity,
Does it?
rather increases the same.
Does it?
Because forthwith is more forthright.
Yes.
Then dictionary says directly, promptly, within a reasonable time. The
Within a
moment you say within a
reasonable
reasonable time, it dilutes forthwith. Anyway, I mean,
My lord, forthwith cannot be used like a word called immediately or at that particular point of time. My lord, I will show that.
Justice Bhattacharya said at the spot.
That is where I did it. My lord, I raised that objection at the spot itself, saying that please give me the reasons why you have rejected.
No, reasons were asked
Sir,
for
what is
by
objection?
way of an email.
I said that give me a reason. They said I will not give
No,
you a
reason. You asked for the reason also by way of an email.
On the spot, I was there. I asked for a reason. That's why they gave it to me on the 20th. And when, Milord, this entire ruckus is going on, where nobody from the other dispensation, Milord, will have any right of, Milord, contesting, Milord, then, Milord, a lot of things come up, Milord, whoever was my proposer, Milord, against him, they filed an FIR. And once a human being, Milord, against him, Milord, an FIR is filed, he obviously, Milord, will sit in the house. He will not do anything. That's obvious. So that is why, my lord, forthwith, kindly have a look at it. This is the Black's Law Dictionary. সবকিছুই ভুল করেই হচ্ছে তোমার আজকাল। Immediately, without delay, directly, within a reasonable time, under the circumstances of the case. I rely upon that. My lord, here, the supplementary affidavit, which says whatever is required to be done, my lord, if I'm, my lord, I give you a lot of an example. I have to file an appeal against, my lord's order. I go, my lord, to the appellate court to seek, my lord, some, my lord, I would say a leave, my lord, to prefer an appeal. Why? Because there is some problem. Somebody, my lord, in the corridor, my lord, catches hold of those papers and runs away. Kindly marks the situation there. Kindly, my lord, visualizes the situation there practically. My lord, if I had not raised any objection and gone away, but very well, I'm very happy with my rejection. I still could have understood a point from the other side. But they acknowledge, my lord, that at that very point of time, I said, please give me reason why I have been rejected. Then when I go, he says, look here, I am not going to take your objections. Whoever, my lord, will see is the person sitting there. I am not going to take your objections. You do whatever you have to do in court. And then, my lord, Christmas comes in. A lot of people might not be very interested, or 7 days time is taken, my lord, to draft an opposition. But it comes within the time permissible. My lord, if I had filed, that's what you're looking for.
No, because your black is different from their.
No, I'm the best black, my lord. There's nobody blacker than me.
No. But yours is the 6th edition.
Yes, my lord. Yes.
And theirs is the 9th
edition. The
In
green
9th
one.
edition, this example is removed. And reasonable time under the circumstances, let me see whether that is there.
Probably still there.
Reasonable time. Yes, that is there.
Still there.
But the case law given in 6th, that is not there. But case law dilutes your case further in your favor. Anyway, I'll proceed on their premise.
Within such time as to permit that which is to be done lawfully and according to the practical and ordinary course of things to be performed or accomplished, the first opportunity offered. So my first opportunity.
No, this is not there in the 9th edition.
It is not there.
So let us.
Lordship takes up the 9th edition. I don't have a problem.
Take up the latest edition.
Yes. Takes up the 9th edition. Because I am on within a reasonable time under the circumstances of the case. So that's why my supplementary affidavit, my lord, becomes very germane, which they have left uncontroverted. They never, my lord, chose to, my lord, even
Supplementary affidavit was filed in the writ or
in the writ co. In the writ co. And his ladyship, his lordship, my lord, took that into consideration.
Yes.
And my lord then said that this is within 5-1. Moment I raised an objection, my lord, his ladyship held, is partaking, my lord, an objection as per rule 5-1.
Yes, the rest.
And there was, my lord, a specific averment, if I'm not mistaken. They said that they are not going to use an affidavit against it. So my whatever I've said in that supplementary affidavit,
Recorded in any order?
probably, my lord, if I'm not mistaken. We'll find. I'll try and find it out. But I remember it very, my lord, distinctly, because they were in a hurry to, my lord, declare the results. It's only, my lord's interim order. Initially, when I moved the matter, my lord, before your lordship, it was for that, my lord, they were unable to, my lord, declare the results. Because once the results were declared, I had nothing else to do. So they were in a very big hurry, my lord, saying that elections are over, we want to declare the results. And for 1 year,
that interim order was passed by Justice
by my lord.
My
lord.
In the single bench?
In the single bench.
Then should I take up this reference?
Certainly. Nobody has the problem.
Oh, it had come up before me also.
Your lordship, for 1 day, my lord, it had come up. Your lordship remembers a junior advocate was submitting, my lord. He came up before your lordship, my lord passed and page 130. ठीक है 130.
He was a junior advocate.
But he argued very well.
Yes.
But then I suffered it's not always, he will grow to understand that it's not always that you argue well and don't suffer an order.
Yes.
দেখি বলে দেওয়া হয়েছে তুমি তখন ঘুমাচ্ছিলে কোথাও একটা। Then kindly turns to Milord.
Mr. Kormaka is trying to prove something to somebody.
Milord, maybe they are online.
We don't know.
Paragraph 49. Upon a harmonious reading of Rules 1 and Rule 2 or Rule 5, I hold that the objection against rejection of nomination is to be made immediately and without any delay, and it should be made at the spot, kindly marks that, or within a reasonable time immediately thereafter. So his lordship probably, my lord, takes some sort of, my lord, inspiration from this, but within a reasonable time under the circumstances of the case, that his lordship, my lord, overlooks. Even if for some reason the objection against nomination could not be made at the spot which is made, the same has to be done within a reasonable time. Reasonable time, however, shall depend on the facts of each case. In this regard, it is to be borne in mind that the list of nominated candidates are to be published after the last date of withdrawal. Marks is very important. This is the, my lord, where the error, my lord, creeps in. Are to be published after the last date of withdrawal of nominations, and several steps are to be undertaken or to be undertaken thereafter in terms of the relevant rules, more particularly Rule 8 thereof. This comes in, my lord, in January 9. January 9.
But no date of publication of the
No.
in the schedule.
My lord, your lordship refreshes my lord's memory. Kindly takes up page 97.
No, it was the scrutiny.
It was absent.
Scrutiny, then withdrawal within 3 days before after.
Yes.
And then directly dispatch.
Yes.
That was on 9th and 10th of January.
Yes. 9th of January 2023.
So, that's very well. There was no specific date fixed for the declaration of the names.
No. আবার বলছি বলা হয়েছে তুমি ঘুমোচ্ছিলে তখন। Record reveals that in pursuance of Rule 8(1) of the election rules, the names of the nominated registered pharmacists was published on December such and such. The authorities cannot, however, be faulted for publication of the names of nominated candidates in Rule 8(1) on December 27. The objections were filed only after such publication for reasons best known to the writ petitioners. Considering the relevant dates for scrutiny of nomination, withdrawal of nomination, and the publication of the names of nominated candidates, the objection filed on such and such cannot be held to be within the reasonable time in the facts of the case on hand. Therefore, the objection filed on January 1 against the order of rejection is a highly belated one.
No, he has a point there also. I mean, after the names, the nominations are published, After that, you come up with with your
There was
objection.
no date given
It
for
will- It
publication.
will upset the entire procedure. Again, it will have to go back.
Upset in the sense, my lord.
If nominations were not published, we could understand.
There was no
On 20th, you come to know the reasons.
There was no date given for publication.
But
If
even
I
then-
would have understood, my lord, then I know.
You waited till the publication.
No, I would have known, my lord, that there is a date for publication and I had to come with before that. They could have waited, my lord, till whatever time is
How
reasonable.
will they anticipate? You never.
Even I didn't, my lord, because they should have anticipated because I raised my objection.
On 20th, they
I
gave you the
raised it.
reasons. You
Yes,
sit
my lord.
tight.
I
You
raised
waited for 7 days.
Yes.
Only after 7 days they published them.
That whether, my lord, after 7 days or, my lord, they could have waited a little longer, knowing fully well that
This
there
is
was
reasonable enough, Mr. Chatterjee, for you to
but
take an objection.
there was intervening, my lord, period. Well, I am not for a second saying, my lord, that it's 7 days is not reasonable or not. I am on, my lord, in the infraction of the breach of law. My lord, take it for instance, my lord, that 7 days is reasonable time. I understand. But there is no law which says that it would be 2 days or 3 days or 7 days. It waits till 9th of January. 9th of January. And this argument also was not made in my respectful submission. The fact that after the publication, my lord, my objections become otiose, that argument, that consideration, that reply was not there. And nothing my lord, in the law says that after publication, I cannot go and say that, look here, take up my objection. And if you don't form a committee, my lord, the committee needed to be formed to look into my objections. The committee could have come up and said that, look here, no, the publication is made, so you are preventing the elections from going on. But who is preventing the election to go on? May I ask this question to myself? Considers this.
How can the election go on without deciding the fate of it?
I answer that. But who is preventing? What is an election in a democracy? That everybody will have a role to play, my lord, in the selection process. Election is basically I the voter, I'm selecting this person, and whoever is in majority comes there. My lord, democracy doesn't say that out of 35 candidates, 25 candidates will be rejected on a ground which is completely alien to law. Completely alien to law. Not even prima facie, on the face of it. It's bad. This is, my lord,
but that was not
prevention.
one of your objections. 25 out of 35 was
In
not
the
one
entire
of your
writ
objections.
petition, that is my objection.
The writ petition.
That is my, my lord, my individual capacity, I'm giving an objection. I cannot do that, my lord, in a group. Once when I come to know, my lord, that all these have been, my lord, dismissed, then in a group, my lord, we said.
The court can enter into that only after it crosses the threshold.
I bow down.
I mean, whether that, I mean, your objection was valid or not.
I bow
Going into this question, this is not a public interest litigation. This is not a challenge to the. The moment you say 25 out of 35, that takes it within the domain of 23-24.
No, no.
That is the difficulty.
Subject to correction, my lord, I'm
not within
very
your
well.
personal
I bow down. I bow down.
Difficulty.
My lord, I bow down. Moment your lordship says that it comes into 23-24 because everybody else has been, my lord.
Yes, the general picture.
I am praying before your lordship to look at it from a different angle. My lord, it can't be, my lord, that out of the 35 candidates, 25 candidates are being rejected on a particular ground, which is alien to Rule 3. But those 10 persons, they are also on the same footing.
These are not on record.
But these are all on record because this is what they have argued. Milord, they have, when they have.
Did not give their dates of birth and.
Kylie looks into it. Nobody cannot.
Because
I am saying, Milord, there was never, Milord, a column. My Milord, nomination paper and his nomination papers are not different. So they could not have given something which is not there in the column. This is natural corollary.
Really?
Then, therefore, the objection filed on January 1, 2023 against the order of rejection is a highly belated one. For such reason, I hold that the Rule 5.1 cannot fall within the parameters of Rule 5.1. Mr. Chatterjee would contend that letter dated 19 December 2022 ought to have been considered as an objection. I cannot accept such contention as from a bare reading of the said letters, it is evident that the said letters were issued only to know the reasons for rejection of nomination. I therefore hold that the letter such and such cannot be construed to be objection. Well, I had argued though I cannot, my submission was this is an initiation of an objection. This was not the objection itself. In my considered view, the writ court should not have embarked upon an inquiry into the reasons for rejection of nomination papers, as the objection do not fall within the parameters of Rule 5.1. In view of the observations made here and before, Mr. Chatterjee would contend that it cannot be shown that injustice has been caused due to improper rejection of nomination. The writ court can certainly step in and interfere. It is not in dispute that 3 out of 4 writ petitioners were present at the time of scrutiny. Therefore, it shall be deemed that they were aware of the reasons for rejection of the nominations at the time of such scrutiny. Miller, this is where the error comes in.
No, you asked for the reasons.
I asked for the reasons.
That is on record.
That's on record. The remaining writ petitioner, for reasons best known to him or her, did not attend at the time of scrutiny. However, the request for disclosing the reasons for rejection was duly complied with. The writ petitioners, even after being made aware of the reasons for rejection, did not avail of the remedies provided under the statute promptly and in the manner as provided therein. Therefore, no injustice can be said to have been done to the writ petitioner as alleged by them. By referring to the grounds of rejection, Mr. Chatterjee would contend that the nomination of the writ petitioner was rejected by the written officer on extraneous considerations. The substratum of the impugned order is the grounds for rejection, which is a secondary issue, and the primary being whether such an order could be challenged under Article 226 of the Constitution of India. The secondary issue will be considered if the primary issue is decided in favor of the writ petitioners. Again, cardinally, my lord, His Lordship first decided the second issue and then went to the first issue. And the finding is the secondary issue will be considered if the primary issue is decided in favor of the writ petitioners. For the purpose of deciding whether an improper rejection of nomination can be challenged by approaching the writ court, I shall now deal with various decisions on the said issue. This is very important.
These are also cited
by His Lordship. Punnaswamy, of course, my lord, was discussed by the Honorable the Chief Justice when the matter was being heard, and also by Justice Bhattacharya, but nobody, not from the bar, it was not cited from the bar. It
You are
was
put
a
on notice.
It
You are
was
put-
yes. It was a haphazard hearing, my lord, be that as it may. Punnaswamy is quoted. Then comes the Honorable Supreme Court, paragraph 40 of the said reports held as follows. We are informed that besides the Madras High Court, 7 other state high courts have held they have no jurisdiction under Article 226 of the Constitution of the entertained petitions regarding improper rejection of nomination papers. This view is, in my opinion, correct and must be affirmed. The appeal must therefore fail and is dismissed in view of the nature. Punnaswamy held against the maintainability of writ petitions while the election is in progress. My lord, all these judgments.
Rule 5.
So I'm not going to trouble your lordship. Kindly skips over. Interestingly, my lord, 65, my lord looks into my lord Ashok Kumar, paragraph 65. And his lordship quotes 65, Ashok Kumar in 66. His lordship quotes number 3, paragraph 3 at page 38. But the finding, my lord, 67, if it therefore follows from the observations made in Mohinder Singh Gill and Ashok Kumar's case that invocation of judicial remedy has to be postponed till after the completion of proceedings in election if an election is called in question. However, if the approach made is to facilitate the completion of the election, such challenge before the court would not be barred. My lord, I am making my submission, my lord, to the extent that by reducing the number of candidates, you are actually not progressing with the election, you are actually curtailing the rights of the citizens.
Actually, arguably, Ashok Kumar's this para 3, sub-para 3 of 32, that puts election challenges on at a par with other things.
At a par.
Because malafide arbitrary are the windows for ordinary challenge also, 226.
But his lordship thereafter, my lord, holds differently.
Obviously, yes.
Differently. I'll show your lordship quickly that. Any action taken or orders passed by the authorities vested with the power to conduct election can be made the subject matter of judicial review on the ground of malafide or arbitrary exercise of power of such authorities if the approach does not amount to calling in question an election. Therefore, there is no conflict in between Punnaswamy and Mohinder Singh Gill and Ashok Kumar. On the other hand, insofar as the maintainability of writ petition qua the challenges which tends to interrupt obstruct or protract the election, all the aforesaid decisions have been held that against the maintainability of writ petitions wherein challenges have been made against any step connected with the process of election before declaration of the results, if it has the effect of interrupting, obstructing, or protracting the election. Now, the question arises whether improper rejection of nominations can be challenged by a filing of a writ petition. Now, the consideration starts. Honorable Division Bench of the Honorable Bombay High Court, after noticing conflict of opinion of two division benches on the point whether writ petitions under Article 226 of the Constitution of India would be maintainable, challenging the orders of rejection of nomination form, thought it appropriate to refer 3 issues for decision by a larger bench, and one of such issue which is relevant for the case on hand was as follows. Thus, allowing a challenge in a writ petition to rejection of nomination form, my lord, I am not again doing this, my lord. Why? Because Rule 5.2 was not there. 5.1 was not there. This is a judgment of Justice Dipankar Datta, if I'm not mistaken. Issue of rejection of nomination papers was raised in Punnaswamy against 75-76.
I told Mr. Kaur, the Chief Justice of the Bombay High Court, with his conservative views.
His Lordship, Lord.
Mr. Kaur fully agreed. Fully
agreed.
Yes.
His Lordship, Lord.
His Lordship will also agree.
Yes, yes. He very openly agreed.
He openly agreed.
Openly agreed. Lord, he interfered in that Taposhpal matter. Lord, I was very surprised because I moved it before him. Lord, I told the client that nothing's going to happen.
With a lot of reluctance, maybe.
No, my lord, his lordship, after seeing, my lord, what was, because it was shown in open court, my lord, the speech, his lordship was very moved. Because first, I thought the writ petition was very badly, my lord, drafted. There was nothing in the writ petition. But his lordship, my lord, said that this can't stop, his lordship opined that illegality has to be looked into by the courts. And I think, my lord, that was the first matter which brought in, my lord, the High Court to really interfere, my lord, with these
series of.
That was the first matter where the High Court really interfered, where, my lord, a political speech was being given and the entire situation, my lord, was being, my lord, corrupt. After that, many matters have happened. But before that,
probably the media also had a role to play.
Media has a massive role. Massive. Because judges are humans too.
The media, in the sense that it was brought to the notice of
Yes,
the public and the court.
Yes, absolutely. Then 78, my lord, Shaji Joseph, my lord, was considered. Then your lordship turns back, my lord, to 79. Very importantly, looks to 81. Rather 79. In view of the aforesaid well-settled binding precedents, the question raised in the appeal has to be necessarily answered in the negative. I therefore hold that improper rejection of nomination cannot be assailed by filing an application under 226, and the learned single judge was not justified in allowing the objection against rejection. Then 81. Accordingly, this appeal stands allowed. The impugned order dated Sansa stands set aside and quashed. Consequently, the writ petition Sansa stands dismissed. There shall be a direction upon the returning officer to conclude the election process and to publish the result as expeditiously as possible, but positively within 4 weeks. The respondents' numbers 1 to 4, as well as any other aggrieved person, are left free to approach the competent authority as per the 1948 Act and the rules framed thereunder for referring the dispute in accordance with law if they are advised to do so. There shall be, however, no order as to come.
What is the conclusion of the Chief Justice?
Yes. It affirms, my lord.
Where is that?
I'll tell you. Just, it is at 24.
24.
No, Chief Head, last head, 8. Kindly looks to 24.
Yes.
Which is at page 23.
Right.
I am of the further view that there should be an observer nominated by the government to ensure that the entire election process is conducted in a free and fair manner without any irregularity or complaints. Therefore, while affirming the decision of the learned single bench, it is directed that not only the correctness of the rejection of the nomination of the writ petitioners should be considered, but also such of those 21 nominations which were rejected, whoever files objection is required to be considered by the committee in terms of Rule 5.1 of the election rules. In order to ensure that the election process is conducted in a proper manner, we direct the Secretary, Ministry of Health and Family Welfare, Department, Government of West Bengal, to nominate a senior officer of the said department to act as observer To ensure that the election process is conducted in a free and fair manner, the observer is required to make made known all the developments and all actions and decisions should be taken in the presence of the observer. The
No,
appellants
this is extra. I mean, the
Yes.
previous paragraph, last sentence probably sums up your challenge.
Yes.
The election process needs to be pushed back to the said date and the
Yes.
objections of the date of scrutiny.
Yes.
The objections as well as such and such were
Yes, ma'am.
rejected to be considered by the three-member committee.
Man.
So this was your.
Yes.
This is my division bench in my single judge order.
by a
So
legal fiction-
with a vengeance, I have got a chance now to sit in judgment over the division bench.
My lord, by way of legal fiction, your lordship, my lord, as a single bench, my lord, has become, my lord, the appellate forum of a single bench.
Of a division bench.
And a
Of a
division bench as well.
Anyway, so this is.
My lord, there were two instances in our lifetime. If your lordship remembers the British Airways case,
Yes.
that was probably the first case that I remember. Before there were plenty, there would be, my lord, division benches who would, my lord, differ. And the division, surprisingly, this division bench did not, my lord, fall apart. Earlier, when they differed, the benches,
Most cases.
they would, my lord,
Most of the cases.
change.
Most of the cases.
Because I remember even in British Airways, I
But
know
that shouldn't be what I mean.
this cannot be. There can be, all are human, there can be two views.
I mean,
These are not personal things. These are
absolutely,
views
yes.
on law, my lord. These are not personal.
Absolutely.
We
There are people who follow their own. I mean, anyway, let us.
they have their own, my lord.
No, we follow our own judgments. Up
I-
to. Yes. Anyway.
I
The moment you
understand.
deliver a judgment or even if you make an argument, that is public property in the public domain.
The public domain.
So you are
And,
not the owner of that.
Not at all. And you speak through your judgment.
Yes, you have spoken, forget.
That's it.
Move
Over,
on to the
done with,
next.
finished. You don't have to go to the media and say that, look here, I did this.
Not even that. I mean, anyway, let us.
You do not need to justify your judgment. Let's put it
So
that.
there are 2 points. Article 226, you say your primary contention is 5.1 is there, which is not there in Ponnusamy and in all of the following judgments. Plus Ashok Kumar is there. It opens up at a par with other 226 matters. So these are the two things primarily. And regarding your the objection whether the limitation period forthwith, you have also relied on black
And on that, reasonable time.
reasonable time. Yes.
And why I say reasonable time? Because the outward challenge, my lord, is January 9th.
Oh, and you say that initiation, Justice Moushami Bhattacharya accepted that.
Yes.
And the chief, not in so many words,
No,
but accepted.
accepted it. Saying that
Accepted
it was for
initiation.
His
It was
lordship completely overlooks that. He says that's no objection at all.
No, his lordship, Justice Hiranmaya Bhattacharya, one point is very that is also very arguable. I mean, that after the nomination was published,
Yes,
they waited for 7 days.
Yes.
That is also a very plausible.
Yes, I bow down. But then, my lord, it is not for the division bench to, my lord, put forward its own view.
That is a third issue here
Yes,
involved.
that's
I mean,
why I
how
say,
far
but-
the appellate bench can interfere.
Should or can maybe, but should
No,
not.
can definitely. I mean, intercourt appeal.
Can but should not. And with respect to that, my lord, I have my lord's judgment.
2019 1 CHL
2019 volume 1
Your
Calcutta High
bag
Court
has come.
notes. Yes, my lord. My lord, my bag hasn't come, my lord, but it's there here.
This is Mr. Kormakar's bag.
Mr. Kormukar, my lord, has a bag full of tricks.
Yes.
So this was followed in this judgment to observe giving observations after division.
Lord, I'm not troubling your lordship, my lord. Digby. 19 CHN 328.
এখানে allow করেছিল অ্যাডমিটটাকে কিন্তু এখানে disallow করেছে।
দাঁড়ান, একবার দেখিয়ে দিই। Paragraph 22 onwards, your lordship will find. I'm not, my lord, reading the entire. That will be a complete waste of time, your lordship, my lord. Just refreshing my lord's memory, my lord. 22 it starts. And
No, this is not in my memory. I actually signed. I looked through the paragraphs, but signed.
my lord has not differed, so it's lordship's as well.
Definitely, yes.
My lord as well. Then, my lord, 35, 36, 37, lordship sees.
এটা টুলটা এখন দিচ্ছি জাস্ট এই একটা সাইট এবং কনসেপ্ট has arrived at a specific point list to set patent.
But you have given the citation for them.
Yeah, I have given. My lord, he uses my SEC online, doesn't, my lord, spend. This is, my lord,
I have an inherent right.
no, not anymore. My lord, 2023 SEC online, Calcutta 401, following my lord's, this honorable division bench. This is by the, in the Taposh he appeared in that matter. No. In that, my lord, Taposh Pal matter, Justice Chakraborty differed.
Yes.
This is Justice Chakraborty's judgment. Looks to paragraph 25. 25.
But please give printouts so that it's
I will
convenient.
definitely, my lord, we'll make a bunch, not the bunches that my learned senior friend has already given to your lordship,
Yes.
but the other bunch we shall give you.
Para 20?
25. My lord, do not, after your lordship finishes,
Yes.
do not for a second think that I am making a submission which says that the division bench cannot.
No, cannot be.
But there are riders.
Definitely.
If there are two possible views, and if one possible view has been taken, it's not for the division bench, my lord, to even for the appellate court, basically. It's, my lord,
Yes,
the judgments came in from the injunction matters.
Yes.
Injunction matters.
All.
So it was not open for Justice Bhattacharya to put in his lordship's own, my lord, view in a case where two views were possible. I say, my lord, I'm taking my case a little further. I say, my lord, Rule 5.1 is peculiar. Rule 5.1 gives me a right. You cannot take that.
Rule 5.1 is your best argument on.
That's my, I am on that. All these cases cited by my learned senior friend in the other side, my lord, the peculiarity of Rule 5.1 is absent. আর কিছু বলবো বলে দিয়েছি আগে বলে দিয়েছি আমি বলে দিয়েছি
Do you have the list of judgments you wanted to
there was the bunch is there and the list of judgments I'll make one, I'll give it to you lordship. Lord, I have distinguished their judgments, Lord, on the basis of facts, and 2 or 3 judgments which I am relying upon some of them. Ashok Kumar, Mohinder Singh Gill, everyone, I am relying upon them. Chess Association.
So instead of prolonging it for another day, I mean,
I don't want to.
You can just.
I'll just hand over, my lord, that bunch, maybe a written notes of argument as well, along with the bunch, and hand it over to your lordship. There's nothing more, my lord, I need to add.
Yes.
They want me to show your lordship the Dental Council rules. My lord, take it from me. I will jot it down in my rules. 5.1 second part is absent everywhere.
No, the rules were handed over by Mr. Corporate.
It's not
either
there.
it was handed over or it's
Probably, my lord, it was the rules with respect to Pharmacy Council is there.
Oh, I'm sorry.
Because they relied upon Dental Council.
Achha.
That rules.
There 5.2 is not there.
Achha,
very
not
good. YouTube.
Not there. Lord, it's with me. I do not want to burden your lordship. I will extract it from this rule and will not put it in my written notes of argument for your lordship to consider. I'll give this to my learned friend so that he sees.
Dental Council, I mean, 2 days back,
that was the judgment relied upon by them.
No, 2 days back, I passed an order on the Dental Council itself. An election process was challenged by Mr. Kolol Bush, but that objection was not taken. But in any event, the
doesn't have the rules doesn't have.
That objection was not taken actually.
Not taken at all. But the rules also don't give them a right, Lord, with respect to the nomination paper. That becomes an election dispute per se.
And then which interpretation has to be made?
So very well, then indicate to them, Mr. Chatterjee. Indicate to them what judgments you will be citing.
The ones which I had given.
Only these.
83 today. 83.
Whatever judgments you independently cite, just give the citations.
My lord, the first judgment that I really, my lord, I feel is germane here is 1983, volume 2, SCC 433. This is Titagarh Paper Mills Company Limited, where, my lord, it's been held that if a statute wants a certain thing to be done in a particular way, it has to be done in that particular way and in no other.
But that goes against you also.
No, 5.1.
Forthwith.
5.1, my lord. If forthwith, I am saying is ambiguous.
Depending on the interpretation.
Yes. It depends upon the situation, depends on how it is done. This is the judgment for that. Followed in, my lord, 2005, volume 2, SCC.
Now, which paragraph of this, Titagarh?
My lord, paragraph I'll tell you. আচ্ছা বস, আস্তে 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 বস, তাড়াহুড়ো করছি না যখন তুই করছিস। The 83 judgment. Yes.
The head note is written 6 and 11, so I'll go through
yes.
those.
433. It was right at the end. I'll just give me 1 minute's time. I'll tell you. কোথায় গেল রে? statute যেখানে করে
Para 11.
I'm sorry, but I'm really sorry.
But here
Yes.
it was said 226 is not maintainable.
Yes. No, it says that the act, the way the act says, well, I'll give you also another judgment as well. Where the act says that it has to be done in that way, it needs to be done in
Para
that way.
11, middle of that, the Act provides for a complete machinery to challenge, and impugned orders can only be challenged by the mode prescribed, not by a petition under 226.
Exactly.
Rule 5.
But you are relying on it on a different
Different
context.
footing, I am saying that the machinery had to be followed. And because it has not been followed, 226 lies.
This was
Well,
this line was followed in 2015, 13.
Lord, this was also followed by টিকা করে না 2018 জাজমেন্টটা তো ওটা পরিষ্কার করে বলা আছে।
Yes.
This was followed in 2015 volume 13 SCC 722. 15 13 SCC 722.
Para 14.
Huh.
Para 14.
Para 14, my lord, where the law prescribes a thing to be done in a particular manner, following a particular procedure, it shall be done in the same manner following the provisions of law without deviating from the prescribed procedure. When the provisions of Section 3 of the Act clearly mandated the authorities to pass an order of detention at one time for a period not exceeding 3 months only, the government order in the present case directing detention of the husband of the appellant for a period of 12 months.
So why are you relying on this? I mean, Rule 5.1 is the prescription, and that has to be followed, not 23.24.
No.
Regarding these nominations. Very.
Lord, 23-24 comes in only when the larger picture of election comes in. But if 5.1 second part was not there, 23-24 would have come in. I am making the submission before your lordship. But once the right is given, it had to be followed.
If ambiguous, then how to interpret?
Dictionary meaning.
The intent of the
Correct. ওটাতেও তো বলেছে ওই জাজমেন্টটাতে জয়দীপ কৌশলের জাজমেন্ট takes up 2005 volume 2 SCC page below is 271. Have a look at paragraph 13.
15 and 17.
The interpretive function of the court is to discover the true legislative intent. It is tried that in interpreting a statute, the court must, if the words are clear, plain, unambiguous, and reasonably susceptible to one meaning, give to the words that meaning irrespective of the consequences. Those words must be expounded in their natural and ordinary sense when the language is plain and unambiguous and admits of only one meaning. Suppose, Miller, it was given for 4 days, for 5 days, no problem. But forthwith.
Mr. Kormakar found out this judgment?
Yes, yes. Miller, he has a bag of tricks. Man.
This should have been cited by them.
No, can be cited by us also. One paragraph. When the language is plain and admits to only one meaning, no question of construction or statute arises, but the act speaks for itself. Miller, if it's wrong, then it's cited by me. Courts are not concerned with the policy involved or that the results are injurious or otherwise, which may follow from giving effect to the language used. This can be for us. If the words used are capable of one construction only, then it would not be open to the courts to adopt any other hypothetical construction on the ground that such construction is more consistent with the alleged object and policy of the Act. In considering whether there is ambiguity, the court must look at the statute as a whole and consider the appropriateness of the meaning. in a particular context, avoiding absurdity and inconsistencies or reasonableness which may render the statute unconstitutional. It is equally well settled that in interpreting a statute, effort should be made to give effect to each and every word used by the legislature. The courts always presume that the legislature inserted every part thereof for a purpose, and the legislative intention is that every part of the statute should have effect. The construction which attributes redundancy to the legislature will not be accepted except for compelling reasons such as obvious drafting errors. This also found place in some of the judgments cited by them on interpretation, the 2021 judgment. I am on, if it was given that I will have to put in an objection within 3 days, that is definite. Moment you say forthwith, you are keeping something open, and then looks to the surrounding circumstance where you have kept the date till the 9th of January. There is no date given for publication of the accepted nomination.
So how is the plain meaning interpretation rule helpful?
5.1 second part, plain meaning, that I'm strictly on that. Strictly on that. সেটা আমি বলেছি। In the I was loosely saying to your lordship about the Chandigarh polls and the Calcutta High Court. We found out some of the judgments from the Calcutta High Court on the Panchayat polls, where nominations were rejected, there were interim orders granted. These are one of them.
But this proposition was
Cannot,
not.
But it basically to show that the High Court is not shutting its eye and saying that the writ is not maintainable at all and it's an election dispute. It will belong to the same honorable judge. And the Supreme Court judgment on the Chandigarh mayor. These are not propositions of law, but this is just showing your lordship that the Supreme Court did not use Article 142. This is only to show that. Supreme Court said that the High Court ought to have interfered in the matter. I am showing your lordship only for that, to that extent. So basically, my lord, Ashok Kumar comes into play. Basically, the third paragraph of paragraph 32 of Ashok Kumar comes into play, where there is manifested the deep-rooted arbitrariness. The courts can't shut its eye off. And that's why, my lord, the remedial measures were given by the Honorable the Chief Justice, so that the process of democracy, my lord, process of election, which is, my lord, what we are all here for, my lord, the democracy should be protected. That's why his lordship, my lord, brought, my lord, those measures in. My respectful submission at the end is to protect the Constitution, to protect the statute. The High Court needs to interfere, my lord, where there is complete arbitrariness on the basis of by the, my lord, the authorities. And here is one such case.
Yes. So you'll argue today or
Tuesday, Mr. Call instructed me to
Tuesday,
my lord.
Heard learned counsel for the respondents in the appeal, Pushap. For further hearing, let the matter be posted in the list on February 27, 2024 at 2 p.m.
Grateful to us. I was telling Prabhu, my lord, it's a red letter day for me.
Why?
That I won a matter against him.
Yes, come.
Original side matters, any mentioning?
Lord, there
be permitted to mention this matter, my lord. Yesterday, my lord, I had completed my arguments.
Yes.
My lord, that tea estate matter. My lord, the mentioning is because of my incompetence. My lord, I'll need, my lord, 5 more minutes on the next day. My lord, I had concluded, my lord, 2 points, my lord, I missed. My lord, while making my arguments. My lord, I thought, my lord, I should indicate, my lord, the other side also, my lord, because it was for their rejoinder.
This
Although, my lord,
went wrongly as filing of
filing,
return.
yes.
Filing of
For
rejoinder.
rejoinder
It was-
arguments. my
I
lord.
did not say that.
Yes.
I should have corrected.
Lord, I'll not take, Lord, 5-7 minutes more, Lord.
Yes, yes, no
It's
difficulty.
okay, my lord, we don't oppose such.
Take it back. Don't remind me of this mistake.
No.
Yes.
I'm grateful, Lord.
Listed matter item number 1 for hearing. Dalmia Securities Private Limited and another versus the Calcutta Stock Exchange Limited.
Yes. You're the stock exchange.
Yes, I'm the stock exchange. Malad, Mr. Rai was making his submissions. He's not there. He had to leave because of the foot problem, Malad. So if it could be kept on Tuesday, Malad, subject to my.
Hello, we don't have any objection. Tuesday,
Very
my lord.
On the prayer of the respondent, the matter is adjourned till 27th, February 27, 2024.
Court application item number 2, Era Johanna Bose and others versus the state of West Bengal and others.
Lord, I beg to appear, Lord, for some of the respondents.
Yes.
The majority owners, my lord, in this. So this pertains to, my lord, that mandate of, my lord, the Apartment Ownership Act. It was argued it has to be fined within a specified time, which was argued to be mandatory.
Your arguments were going on.
Lord,
We had concluded the arguments, and they were supposed to file the application by way of an affidavit, my lords, which they have filed by way of a letter, my lords. The application which they had filed before the concerned authority seeking registration under the West Bengal Ownership Act, my lords, of the society. And my lords, we have also prepared a reply to the application which they have filed, my lords. May I
What is
just
that
seek...
application?
Application
My lords, there's no affidavit.
Lord,
wasn't
I would say,
You
Lord,
filed an application. What have you filed?
Lord, your lordship wanted me, Lord, to put on record by way of an affidavit, Lord, indicating, Lord, how the process of applications were carried out.
Yes.
Lord, all the papers are there, Lord. Unfortunately, Lord.
Come back on Monday then.
Yes, Lord, grants me.
It has to come by way of an affidavit.
Yes.
Later won't.
The papers are already there, Lord. Only by way of an
file an affidavit. Give a copy by email to them so that.
Then, my lords, I'm not filing this. I'll deal with that. And
yes. If necessary, I'll take that on record.
Yeah.
And Lord, necessary, I'll take that on record on the next day.
Lord, I'll just make 2 submissions on that particular day regarding the notice.
Whatever. Yes.
Lord, I'm representing state in this matter, my lord. We have done this registration in compliance with the provision of law, my lord. A bunch of paper, my lord, kindly allow me to file my opposition, my lord. Because I want to keep these documents on record, my lord. My lord, the petitioner, they are relying upon the order of the division bench, my lord. We were not the party over there, my lord. We were having no information with regard to the
Are you
guideline of
enjoying
the
any
division
interim
bench.
order?
yes,